Good morning, everyone, and welcome to this third agenda of the Joint Interim Standing Committee on Commerce and Labor. Mrs. Hoffaker, please call the roll.
Senator Lang, Senator Stone, Assemblywoman Backus,
Present.
Assemblywoman Kasama, Assemblywoman Marzola,
Here.
Assemblyman O'Neill,
Here.
Assemblywoman Torres,
Here.
Chair Spearman.
Here. So, and if there's anyone absent, those who are absent, please mark them present once they enter the room. So before we begin, I'd like to go over a couple of housekeeping items. And the first one is, it's a rather somber day. This is the 56th anniversary of the assassination of the Reverend Dr. Martin Luther King, Jr., April the 4th, 1968. It was a very sad day in the history of our country because it was an assassination that was basically based on race and dialogues around that. So in light of the challenges that we face today, what I'd like to do is I'd like to start with a moment of silence in honor of the work that not just Dr. King did, but all those who are still fighting for justice, still fighting for equity, and still fighting for equality. Thank you. Let's start with some housekeeping items. If you get one of these, a little computer that you can hold in your hand, make sure that you turn it off, the ringers, and you can put it on vibrate or whatever, just so that it doesn't disturb those who might be testifying at the dais at the time. Members joining online, please mute your microphone when you are not speaking, but leave your camera on. For the individuals on Zoom, please be sure to mute your microphone when you're not speaking to minimize the background noise. And in addition, for Zoom participants, the chat feature is only to be used for technical assistance with broadcast and production services. It is not to be used for any communication between members or by presenters unless requesting technical assistance from BPS. The committee meeting materials can be found on the Nevada Legislature's website, and you can also sign up for electronic notifications related to any activity on the committee's website. If you wish to testify in person, please sign in at the table by the door and leave a business card. If you do not testify, you may also want to sign in so that there is a record of who is interested in a particular topic, and in the event the committee needs to contact you later. When testifying in person, please turn the microphones on to speak directly into the microphone. Please turn off the microphone when you are done speaking. We have listeners and viewers who are in Carson City and those who are online, and if you do not speak directly into the microphone, they cannot hear you. We're recording the meeting, and it will be available on the legislature's website. We'll have public comment period at the beginning and at the end, and public comment is limited to 2 minutes per speaker. And for those of you who may be new, maybe just joining us for the first time, we listen to public comment, but we don't ask questions, nor do we respond. That is the time that the public can bring us information, and sometimes we take notes. Many times we take notes, and we may contact the person or persons at a later time. In addition to testifying in person, members of the public may also provide comment in 4 different methods, all of which are listed on the agenda. You can provide public comment by calling 888-475-4499. That's 888-475-4999. Meeting ID is 845-3756-2583, and then press pound. You can email your comments to clinterim@lcb.state.nv.us, and you can also mail written comments to 401 South Carson Street, Carson City, Nevada, and by faxing it to 775-684-6400. You can find the phone and fax numbers, email address, and all of those on the agenda. If you want to notify people that you're coming up or you're waiting on somebody, we've got a pretty powerful agenda, but it may not be jam-packed. So if there's someone that you're waiting on, you may want to ask them to hurry up or slow down. So if we get through in enough time, we're plugging along, we may not take lunch, but if we're not, then we'll do a 30-minute lunch right around noonish or so. So we'll start with public comment from those in the physical locations and then move to public comment from anyone who has called in. Is there anyone here in Las Vegas that wishes to make public comment at this time? Don't see anyone. Is there anyone in Carson City? Broadcaster, is anyone on the line?
Thank you, Chair. The public line is open and working. However, there are no callers at this time.
Okay, we'll give it a couple of minutes. Okay, thank you. So there'll be another public comment period at the end of the meeting, and remember, you can also submit a written statement, which will be added to the record. And please submit your written statements no later than 48 hours after the meeting. So let's move on to agenda item number 3, approval of the minutes. Members of the committee, are there any questions regarding the meetings, the last meeting's minutes? I can talk. If there are none, I'll accept a motion to approve the minutes.
So moved.
What was that? Okay, have a just a minute. Push the pause button. So we will proceed. I have a motion by Assemblywoman Marzola and a second by Assemblywoman Kasama. Any discussion? All those in favor, aye. Aye. All those opposed, same sign, no. I like to do that to see who's listening. And the motion passes. Agenda item number 4. Presentation on national trends in occupational licensing policy. And I believe we have Matt Schaefer, Deputy Program Director. He's on Zoom. He's going to do a PowerPoint presentation. And so with that, the focus of our meeting on occupational and professional licensing, this is one that we have taken up for, I think, about the last 6 or 7 years. And it started off primarily being something that would be available for military spouses, but we also saw that during COVID, it became a very practical way to make sure that medical resources were in the right place that they needed at the right time. So, Mr. Schaefer, the Council of State Governments will provide an overview of the trends and what safeguards there are for the consumers and the needs of workers and businesses. Mr. Schaefer, please begin.
Good morning, and thank you to Chair Spearman and members of the committee. My name is Matt Schaefer with the Council of State Governments. It's a pleasure to be with you this morning talking about this very important topic. Just a little bit about CSG. If you've never heard of us before, we were founded in 1933. We are a nonpartisan membership association for elected and appointed state government officials. You may also be familiar with our Western office, which is based out of Sacramento, but we are a policy organization that champions excellence in state government through convenings, sharing best practices, and research. One program that we have at the Council of State Governments is the National Center for Interstate Compacts. And this Compact Center is a technical assistance provider around the creation, enactment, and administration of interstate compacts. And we're really the only group out there that is providing technical assistance on interstate compacts. So we do have a little bit of expertise in this particular policy area. So today we're going to talk about trends in occupational licensing, and I'm going to focus particularly on mobility, and our particular expertise is in interstate compacts, and I'll talk about a couple other things that states are doing as well to address this mobility concern. But just to start and talk about compacts. So what do we mean by this term interstate compact? What precisely we're talking about here is a contract between states. So these compacts are legally binding amongst the states that enact them, and they're also legislatively enacted. So they're a creature of the state legislature. That's the entity that is essentially signing your state up to participate in this legally binding agreement between states. Now, compacts have been used for centuries for a number of different reasons. One example you can see there on your screen is the driver's license. So rather than the federal government getting involved in driver's licenses, the states came together and created the driver's license compact, which allows you as a motor vehicleist to hold one license issued by your state of residence and drive anywhere you want across the country. And that's done through the driver's license compact. And these occupational licensing compacts really operate in a similar manner, where the principle is you hold one state issued license and you can practice in all of the other states that are a part of the compact. So over the past decade or so at CSG, we've really seen a explosion of interest in states using compacts to solve issues around portability. So the primary purpose here is to facilitate multi-state practice. So allowing a practitioner to be able to practice in multiple states without having to navigate each state's individual state-specific licensure process. So the analogy of the driver's license that I just gave applies here. You maintain one state issued license and you can work in any state that's a part of the compact. We always mention the point that compacts help maintain, or in some instances improve, public health and safety. This is largely down to the amount of information sharing that occurs amongst the member states. So sharing things like current investigations, any kind of final board action, any kind of regulatory action against the licensee, all that's shared amongst the member states. And so we're really raising the bar in terms of regulation, providing licensing boards with more information than maybe they currently have access to. And then the last point here, preservation of state authority over professional licensing. So this is certainly not a takeover of any licensure pathways that currently exist in Nevada. So you can have alternative pathways to practice. You have Nevada state-specific licensure pathways. The compact is just an additional pathway to allow practitioners to be mobile or work in multiple states. The other thing to emphasize here is that these compacts never touch scope of practice. So Nevada continues to define for itself state-specific scope of practice. So what it means under the Practice Act to perform certain procedures or have a certain scope, Nevada continues to define for itself what practitioners are allowed to do when they are in the state of Nevada. And so that's a very important point to make. We're just creating a alternative pathway to practice, but while practitioners are in that particular state, they have to abide by the scope that that state has dictated. You can see here just how popular these compacts have been in recent years. We have 16 professional licensing compacts now and over 300 pieces of legislation enacted just in the past 8 years. Here's a list of all of the active interstate compacts. You can see there, nursing, medicine, and psychology lead the way. They're the oldest, the most mature compacts. They've been around for about a decade now. PT close behind there. The compacts on the right side of your screen have lower membership, but that's just because they're newer. All of these compacts were created, or the majority of them were created through a cooperative agreement that we have with the Department of Defense to create new licensure compacts to help military spouses. And these compacts are relatively new. They've only been out to the legislature for one legislative cycle. Typically, we see these things tend to take 2, 3, 4 years before they get a good number of states on board. Here is an overview of where all of the states are in terms of their membership to these licensure compacts. And you can see there the 5 compacts that Nevada has enacted for EMS, massage therapy, medicine, psychology, and teaching. So you can see there Midwest and southern states are particularly friendly to these compacts, but we see almost all states have adopted these at this point. Okay, so this slide has a lot of information on it. I'm not going to go through it point by point. Really, the purpose of this slide is just to display our compact development process. So this is not a situation where CSG just goes in a room and writes a compact on behalf of the profession. This is a very broad and inclusive process that includes stakeholders from these professions and the public at large. So we have a broader stakeholder group that creates a framework for the compact. We then convene legislative drafters to put pen to paper. We have a lengthy public comment period where the compact language can actually be reviewed, and we are receiving public comment about the provisions in the compact. All of that to say, we want as much input on the front end as possible, because these are contracts. They can't really be changed substantively after they are finalized. And so we want as much input and inclusive dialogue as possible on the front end, so we avoid a situation where you have to change the compact after it's already finalized. The second phase here is when the compact moves to the legislative component, and CSG is available to provide education on all of these compacts. We don't actively advocate or lobby for compacts, but we're available as an educational resource for you as you consider them. And then lastly here, we transition to the governance of the compact, the implementation, and ongoing administration. Okay, so let's talk a little bit about benefits here. So obviously the primary benefit we're talking about is increased mobility. Practitioners are no longer bound to only practicing where they hold a license, but we're able to practice in other compact member states that have enacted the legislation. I think telepractice is a big driver of the prevalence of some of these compacts. You think about some of the behavioral health professions that are looking at these, professional counseling, psychology, social work, high utilization of telepractice, and the compact really alleviates a lot of burdens associated with telepractice, where you may need to be licensed in 20 or 30 states at one time if you're seeing clients from all over the country. I know the Department of Defense is on the agenda for today, so they'll speak more to this point about how compacts support military families, but DoD does say that compacts are the best long-term solution for their military spouses in terms of reducing barriers to licensure for that population. Benefits to board. So compacts create an agreement on uniform licensure requirements. So in the compact language itself, it's listing out kind of uniform standards that all the states are agreeing to. And I think you'll notice from the list of compacts I provided on the previous slide, a lot of healthcare professions are looking at these. And I think that kind of lends itself to the point that compacts thrive on uniformity. And that's where we see the most significant amount of uniformity across states in terms of their requirements is in healthcare professions. So what it takes to be an occupational therapist in one state is really kind of standard across all of the states. And so I think that's why we've seen such a high uptake with healthcare professions looking at compacts. A shared data system. So the compact, through the implementation process, creates a shared data system that all of the states have access to, sharing things like investigative information, any kind of board disciplinary information about licensees. All that's shared in the data system, and boards who are a part of the compact are getting real-time updates about disciplinary issues that are happening across state lines. And then lastly, just generally increasing access to highly qualified practitioners. States really like these compacts as a workforce development tool. So we hear all the time about workforce shortages, particularly in healthcare professions. And so compacts are a way that states can look to strengthen their healthcare workforce. We're certainly not saying that compacts are a silver bullet or something that's going to solve all of a state's shortages, but it is a policy option to explore when trying to alleviate burdens associated with healthcare workforce shortages. Some additional considerations here. So we are not at CSG saying that compacts are a good fit for everybody, because there's a number of things to consider in terms of, is your profession a good fit for a compact? So they do take a significant amount of resources to develop, to create the language, to go through the legislative process and actually stand up the commission, which is a governing agency that implements and administers the compact. So that's a lot of resources that smaller professions may not have access to the type of resources to develop a large compact like this. Size of the profession, I think, is also important to note. If you are a profession that's smaller, maybe a good percentage of your practitioners are located in one particular state, then compact may not be a good fit for you. We look for larger professions that have kind of a spread across all states in terms of where the practice is being undergone. Time constraints, this is a long process. We typically say it's 3 to 5 years from start to finish to develop a compact and get it to the point where it's actually operational. So a lot of times states are having emergent needs around workforce, and a compact for a specific profession where there's kind of an emergent need for workforce is probably not the best solution, just because of the time constraints involved in developing. It does require legislative enactment, which comes with its own barriers in terms of navigating each state's political process and in the legislative environment. And then lastly, concerns around differences in standards. This is probably the most significant thing that we hear when states are considering compacts as well. Do my standards match the standards of the other states that are a part of the compact? And this kind of goes to the point that I mentioned on the previous slide, where healthcare tends to really gravitate towards compacts because the standards are so uniform across states. But when you're looking at other professions where maybe there's not that uniformity, one state might have a higher standard or a lower standard. That makes compacts difficult in those circumstances. Okay, this slide is really just meant to display that not all compacts are the same. You can't essentially take out the PT compact and sub in occupational therapist every time you see the word physical therapist. These things are created to fit the specific needs of each individual profession. So you may be familiar with the nursing compact, but that is unique to itself, and each compact is specific and uniquely tailored to fit the needs of the profession. So they have the same general principle in terms of the way in which they facilitate cross-state practice, but there are specific nuances to each of these that are important to understand when you're considering each individual compact. Okay, so that is kind of an overview of interstate compacts. I also wanted to talk about another big trend that we have seen at CSG, and that is the proliferation of universal recognition policy. So universal recognition essentially says that if you have a license in good standing from another state, we will issue you our equivalent license if you move to our state. And so as of last year, there's 20 states, including Nevada, that have enacted universal recognition. And you can see there are a number of the neighboring states around Nevada have considered universal recognition as well. There are some unique features to these universal recognition policies. The states you see listed here, some states have a residency requirement where you're actually required to physically relocate in order to use this policy and have an address in that new state. A lot of these bills have a substantial equivalency requirement whereby the standards from the state where you're moving from have to be deemed substantially similar to the standards that are in Nevada. So if you're moving from a state with a significantly lower standard, then you might not be able to utilize that specific policy. Same thing with scope of practice. Some states have in the bill itself that the scope of practice has to be similar as well. And we see that where states have differences in terms of scope of practice. And so they want to make sure that the scope is similar across states. And then some states also include a recognition of experience in lieu of licensure. So you're not actually required to actively hold a license from another state, but they'll say, if you've been practicing 3 out of the last 5 years, for example, then you can utilize this policy in our state. I want to just talk a little bit about some of the differences here. What's the difference between universal recognition and compacts? Because that's a question we get a lot. My state's already done universal recognition. Why do we need this compact? And so really the key distinction here, universal recognition is making it easier for practitioners to practice in Nevada. So you're making it easier for out-of-state practitioners to come and work in Nevada when they move to Nevada. What universal recognition does not do is provide mobility benefits for current Nevada residents to go and work in other states. So if you're a Nevada social worker and you want to do telepractice in another state, universal recognition does not help you in that way because it's really only for people moving into Nevada. It's not a two-directional form of reciprocity, which compared to compacts, there is that kind of bi-directional mobility. You're making it easier for people to move into Nevada and also making it easier for Nevada residents to go and work in other states, either temporarily or through telepractice. And you can see here is the compact creates the shared data system that I mentioned. It assists with telepractice and allows for practicing in multiple states without having to apply to each individual state to work in that state. Okay, and with that, I will wrap up my remarks, and if we have time, I'd be happy to take any questions from the committee, and thank you again for the opportunity.
And thank you so much. Committee members, any questions? Assemblywoman Kasama.
Thank you, Chair. I'm just curious about the trend because it seems like we are, throughout the U.S., individually doing compacts for different occupational or hygienists or all these different, professions. Is there a trend to perhaps just have one, shall we say, overarching licensure compact that says if you're in good standing for any of these areas? Has any state looked at, and perhaps that's Arizona, just saying for any licensed, occupations, if you're in good standing, we're just going to give a blanket, license to you quickly for any of them, because it just seems like we're all kind of hodgepodging individual occupations.
Sure. So that's really the purpose of universal recognition, is to say, if you have a license in another state that's in good standing, we will issue you our equivalent license when you move here or if you want to practice here. So that's really the purpose of what universal recognition is doing. In terms of compacts, because they are tailored to specifically meet the specific needs of each profession, sometimes we'll see states kind of bundling compacts together into an omnibus bill or something like that. But compacts are typically created for each individual profession because of the specific needs associated with that profession. So if you have a profession like psychology, that compact is essentially exclusive to telepractice. That might not be a apples to apples comparison for dentistry, where dentistry is hands-on. There's not a lot of teledentistry going on. So that's why each compact is created kind of specifically for the needs of that profession.
So just for me to understand clearly, I'm looking at the universal license recognition. I'm picking on Arizona, their neighboring state. So that's a blanket for everything. That could be hygienists, psychology, physical therapy. They're saying all occupations. Is that correct?
Yes, sometimes there are some exemptions for particular professions. I think attorneys are typically exempted from universal recognition. Sometimes medical doctors will also be exempted. So typically the universal recognition will be specific to a title within the state statute. So maybe the title that regulates health professions or the title related to other general occupations. So that's typically what we see for universal recognition, is that it's specific to a title or a chapter within the state statute. But often there are exemptions.
Chair, can I do a follow-up? Is there a trend across the states for, do you see upcoming legislation, or have you had requests from various states? Is there a trend to do more universal or individual compacts?
I'd say they're both being thoroughly discussed at the moment. I think, just because of the amount of interstate compacts, like I shared the list, there's 17 currently that exist. I'd say we see a lot more compact bills just because of how many professions there are. But at this point, I'd have to go back and look at our research for the 2024 legislative session, but almost half of the states have done universal recognition at this point. So it is also a significant number of states who are considering both.
Thank you.
Assemblyman O'Neill.
Thank you, Chair. I had a couple questions, and one of them, Assemblywoman Kasama sort of took from me, because I was curious about that overarching recognition. But along with recognition, Mr. Schaefer, let me ask you, so you have a license to practice some certain profession, and under the universal recognition, you come to Nevada, you still have to apply for a license here before you can practice, or can you start practicing immediately while your license is being processed by whatever the controlling board is? Is that correct? Or I may have missed, you may have already gone through that and I missed it, but could you clarify for me, please?
Yeah, great question. So under universal recognition, they would still have to apply to the board because of that substantially similar requirement. So the board of jurisdiction would have to determine that the applicant from the other state that's coming to Nevada, that the requirements that they satisfied to get the license in the other state is substantially similar to Nevada. So it's not the case that they would be able to start working immediately. And that is another slight difference from compacts, where if Nevada's in a compact with, let's say Utah, for example, we'll just pick nursing, a Utah nurse could come and work in Nevada immediately without any kind of extra application process.
But just so that nurse under the universal recognition could not practice in Nevada until the nursing board approved and licensed her. And that could take days and or months. Am I understanding correctly? But they wouldn't have to go through testing again, or their basic licensing testing. It's just that recognition and approval of their Utah license.
Yes, that's correct. So that's what universal recognition is trying to avoid, is having licensees need to go back to school, get additional education, or retest, things like that. So, but the board of jurisdiction still has to review an application and make a determination that the requirements are substantially similar.
Can I ask one more question, Chair, please?
Yes, please.
Mr. Schaefer, I really appreciate the work you've done here in this presentation, because I'm a strong supporter of compacts and the universal recognition, if we could get people and expedite their licensing. You talked about the positives. I've always going to ask, do you know of any negatives to a state joining the various compacts that have occurred?
Yeah, it's a great question, and I think the list of things that I went through in terms of whether or not a profession is a good fit for a compact. One of the things I talked about is perceptions around differences in standards. So, that's one thing that by joining a compact, you are accepting the fact that another state has legitimately licensed that person, regardless of the requirements that they satisfied to get that license. So, if there's perceptions that Nevada has a higher standard for a particular profession, that might be something that Nevada would consider. Do we want to enter into this compact where maybe a licensee hasn't met our state-specific standards? You're kind of relinquishing that right to be able to pick and choose who you want to practice in Nevada, because by joining the compact, you're saying if this person has a license from another state and they meet all the requirements set out in the compact, those kind of standard uniform licensure requirements, then they can come and practice in Nevada. So, that's not necessarily a bad thing, but it's just something for the legislature to consider.
Has any state joined a compact and then withdrew from it because of some reasoning or an issue along those lines that you know of?
Yeah, so I mentioned there have been 312 compact bills enacted, and there's only been one time that the compact has been repealed and the state has removed themselves from participating. That's the EMS compact in New Hampshire. So they had some issues with their firefighters union in New Hampshire, but that was the only instance so far where a state has withdrawn.
So they withdrew due to a union demand, not a incident where somebody came and was not appropriately educated or misrepresented themselves.
That's
that
correct. And I don't have all of the details to be able to give you a firm answer as to why exactly they withdrew from the compact. But I do not believe it was because of a unqualified practitioner who harmed someone. I know that's not the case.
Very good. I really appreciate the information, and thank you for allowing me the questions, Chair.
Not a problem. Anyone else? Questions? I just have a couple, and I want to pick up where Assemblyman O'Neill left off. You said New Hampshire, and there were some, I guess, some conflicting ideas about compact and unions. So my question is this: how do compacts or not affect CBAs?
Yeah, that's a great question. So from our experience, the compact that has the most involvement from a union standpoint is probably nursing. And I think the argument that you would hear from the nursing unions is that the compact would inhibit their ability to strike, essentially, because you'd be able to pull nurses from another state to come in and fill those jobs when they're on strike. So that's the argument that you would hear from the nursing union. We have seen no evidence to support that notion that would ever happen. And I don't really have any more information to share other than that. We have not ever seen that play out. The nursing compact has 41 member states. We haven't seen that in any circumstance.
And I guess where I'm going with this, and I've heard that argument as well from our nurses here. One of the things that they're concerned with, there's nothing in the compact itself that prohibits a medical facility for calling someone else in if they're on strike. And so you don't have any other information, but are there any states that are working on legislation that would protect those units? I mean, if that's the only reason that the compact won't work for, and you mentioned nurses, and I'll use that. If that's the only reason, are any states working on some type of legislation that would provide them the necessary protection so that they would be able to feel comfortable supporting a compact?
That's a great question. I'm not aware of any. I can reach out to our colleagues that staff the nursing compact and see if they're aware of anything. I'm not aware of anything at this time.
Okay, thank you. So you did a lot with discussing what the future trends are, and my question would be this. Nevada's a graying state, and so I believe it's by 2042, we will be the majority of our population will be over the age of 55. And that means that there will be a lot more specialists that would have to be here. Are we looking at any way that the compacts, as an example, would help to alleviate, for lack of a better word, the burden? In a place like Nevada, we don't have a lot of specialists here of any kind. We're few and far between. So are there any states that are looking at how can they use the compacts, existing compacts, to be able to provide the services for other members of that particular compact entity if or when they need someone? Does that make sense to you?
I think so. And I would just say, I think the more states that join these compacts, the more mobility that you'll see across state lines, and the bigger the impact on workforce. I will say these compacts are in their infancy in terms of being able to point to a specific economic or workforce impact. So there's really only one peer-reviewed study that's been done on compacts. That's the Interstate Medical Licensure Compact. They did find a positive correlation with the number of service providers in a state and being a member of the compact. So I think it was about a 5% increase in physician practice locations compared to states that were not in the compact. So I think more will be coming out on that point in the future as these compacts get older, more mature, more states start joining them. But at this point, like the list that I shared of all the compacts on the slide, only about half of them are currently operating. And so it's still kind of early on in this process to be able to point to specific workforce impact that these are having at the moment.
Thank you. Not to put more on your plate, but that might be a good research project. A lot more people are moving west because of the weather. A lot more people are moving into Nevada because weather, and it allows their retirement checks to go further. So I know we've got a dearth of some specialties here. We're going to be talking a little bit later on about brain health. And so we don't have as many people here that deal with that. The other one would be perhaps some chiropractic or something like that. But as populations shift, I guess what I'm looking at, how can we incorporate whatever is happening with compacts? How can we incorporate that so that it is a read ahead, as you will, for states that are trying to make sure that they're prepared for the onslaught of whatever?
Yeah, and thank you for that. And that's certainly something that we could look into. Like I was saying during the presentation, these things are usually tailored to specific professions. And so, getting into specialties are not typically something that the compacts have looked at. We're typically designed for a large profession kind of broadly, but that's certainly something that we can look into in the future.
And I'll say this for this one, and I think Assemblyman O'Neill has, but so I'm looking specifically now, I'm thinking about maternal health and the mortality rate among black women. So if you have a state where the population of the black and brown population is increasing, and we already know that women in those communities are more likely to die in childbirth than those who are of European descent. You follow what I'm saying? So is
Yes.
there, if we could, and if that level of granularity is impossible, I understand that, but I'm just trying to think how we can use whatever it is that you're doing and how the compacts might be able to help states do a look ahead and say, this is what we need, and not just 20 years from now, but in many cases, there's some states that are struggling because they don't have the right type of specialists in the right place at the right time.
Sure. That is one benefit of these compacts, is that if there is a specific specialty that you need, you'd be able to look across the country and be able to attract those providers to come and work in your state if there's a particular need. So an example I can give now is with social work. A lot of times social workers deal with very specific populations and have very specific specialties. And so, me as let's say I'm a patient in need of social work services, under the compact, I can kind of survey social workers from across the country and pick one maybe that fits the best needs for me in my particular circumstance, rather than just being limited to somebody that's licensed in the state where I live. So I do think it is opening up opportunities for more of that kind of specialized care.
Okay. Thank you so much. Assemblyman O'Deal?
Thank you, Chair. I appreciate the second bite at the apple. You gave me enough time though to think of one other question I had on universal recognition. As you said, Mr. Schaefer, I have the license. I've come to Nevada though, but I can't start practicing until I get licensed in Nevada. Correct?
Yes.
So, but with my using driver's licensing, that compact and/or even some ways a recognition that we have of, I've moved from Florida to Nevada, I can drive on my Florida driver's license for a period of time until I get my Nevada license. So do you know of any states possibly under the universal recognition that will allow the profession to practice, maybe even if they put a regulation that they've been practicing for 5 years or whatever, and while their license is being, or their application for licensing is being reviewed here in Nevada. So they could work immediately in the field of social work, you said, as a nurse, as a dental hygienist, particularly under DOD, and when they move. I know it takes some of the licensing agencies in Nevada, to me, are taking 6 months or better to review and issue license, and even that is considered at times a short turnaround. So what I'm looking at for the question is, any states allow that recognition while they're being processed?
Yeah, thank you for the question. I'm not aware of any. I think for most of these, they are still required to go through the application process, and there's not that ability to practice immediately while their application is still pending. But we can dig into the bills and confirm that for you. But off the top of my head, I'm not aware of any.
Would you please, and deliver it back to to Chair, and she'll disperse to the committee as a whole. I'm really interested about that because I know it's important, particularly Chair and I share that DOD support to get people working and not having to wait exorbitant time for their licensing to be issued. And that's why I was comparing it to the driver's license. I appreciate it. Thank you, Chair, for that second bite. I do appreciate it.
Not a problem. Committee members, additional questions, comments? Okay, well, thank you, Mr. Schaefer. We appreciate the information, and if you could just do me a favor, it's not something that I need next week, but if you can just maybe look around and see if there's any way to expand the trends so that we can look at where the needs are. If there is a deficit and there's a surplus someplace else, maybe we can look at that and use compacts to alleviate that problem. Okay?
Yeah, absolutely. Thank you all for your time.
All right, thank you. Thank you so much. So now we will go to agenda item number 5-1 presentation on barriers to employment faced by veterans, military personnel, and their spouses. I think we have Kelly Mae Douglas. You decided to join us here. Great. Okay. Now, for those of you who don't know, Kelly is, you would think that she has 5 or 6 people working with her. You cover the Western region, is that right? Yes. Yeah, Western region, but she does a heck of a job in terms of trying to make sure that we have information necessary to support our military, their families, in their work as they support our country. So, Ms. Douglas, begin when you're ready.
Thank you, Chair. Do I have this up right, Caesar? Okay. There we go. Okay. Good morning, Chair Spearman, Vice Chair Marzola, and members of the committee. Thank you for having me here. I'm usually presenting via Zoom from San Diego and decided that it was a good chance to come in person. So thank you for having me. Again, my name is Kelly Mae Douglas. I work for the Department of Defense within the Defense State Liaison Office. Our office is charged with working with all 50 state and territory policymakers on policies that we believe could and would make a significant difference in improving quality of life for military families as they move in and out of states. Understanding that many of the issues that military families face are those that are under the purview appropriately of the states. So we like to work together to see if we can find solutions. Our office has worked issues around a variety of topics. More recently, the focus has been on easing barriers to employment for military spouses, to include licensure. But also a big focus for us is on improving quality of education for military children as they move from state to state, and consumer protections for veterans, voting protections for active duty members that are overseas, and other various policies. Let's see. So just a quick note that the reason why we are working these issues and why the Department of Defense is really focusing on families and quality of life is because it has been recently reiterated by the Secretary of Defense and by the administration that taking care of families is at the core of ensuring national security. And you can see the quotes here from the Secretary of Defense. The Department of Defense has a sacred obligation to take care of our service members and families. Doing so is a national security imperative. Our military families provide the strong foundation for our force, and we owe them our full support. And then from Dr. Biden, who leads an effort called Joining Forces, which is an initiative that that has spanned across 2 administrations, starting with the Obama administration, that supports military families and in a variety of ways, to include a big focus on spouse employment, economic security, and education for children. So she said, the families of our service members and veterans, caregivers and survivors may not wear a uniform, but they sacrifice for us all. They give their best to the United States, and we owe them nothing but our best in return. So just just want to frame out why we're doing what we're doing, and then just kind of validating the importance of these types of initiatives to the Department of Defense and the administration. In 2021, there was an amendment to the National Defense Authorization Act, which ensures that the Department of Defense and the secretaries of the military consider certain military family readiness issues when they're making basing decisions for military units and headquarters. And so what that means is whenever there is a decision that needs to be made about where a base might be relocated or where additional missions of a particular base would be located. Let's use the Space Force headquarters, for example. When the Space Force was stood up, there was a search to look for the most appropriate locations for the headquarters. Because of this requirement within the NDAA, all the military services and the Department of Defense had to include not just direct mission related issues, and like land use and availability of airspace and things like that, but also had to include the extent to which states have ensured licensure portability for military spouses and ensured that quality of education is up to par for the children before they decide to move in a new mission to a state. So this is a requirement now that we have to abide by. And so we have to look at what states have done and decide if Nevada, for example, is a good location to be sending families. So our office works on with the states on 10 key issues, priorities every year that are identified by the military services, the installations of families, and community members, and then also with the input of the states. So this is our current list for 2024. This list will be basically the same for 2025 session for Nevada, just for your information. Just one of those issues is coming off. And so I highlighted the opportunities for Nevada, which, as you can see, there is an opportunity in every area of every topic of our priorities for the next coming year. And so I know my presentation is on licensure, but since I have all of you here and who I know are on other committees and other priorities, also have your attention, I just wanted to share with you our global kind of focus for 24 and 25. So regarding our 2024 update to our policy priorities on military spouse employment economic opportunities, a lot has happened since I've addressed this committee last, so I just wanted to provide an update. So first I'm going to just give some context. Many military spouse professionals must relicense each time they transfer with their active duty member. We continue our efforts through a spectrum of policy priorities to ensure that military spouses can achieve portability of their occupational licenses as they undergo their mini permanent change of duty stations. These include timely licensure portability, state accessibility measures, occupational licensing compact enactment, and implementation of the Federal Military Spouse Licensing Relief Act. As I've shared before, as many as 34% of our military spouses need a state-issued license to work. And military spouses are 10 times more likely than their civilian counterparts to move across state lines. I have a couple of other facts I wanted to share with you. Every other year, Department of Defense puts out a survey to active duty military spouses. We also put out another survey to reserve spouses, but this particular, I wanted to focus on active duty military spouses. So in the most recent 2022 survey, we found that 50% of military spouses have a bachelor's or higher degree. 21% are experiencing unemployment at any given time. 27% had to take a job outside their license field upon a PCS due to challenges in licensing. Want to add that on, just another layer of why this is so important. In this recent survey, 20% of the military spouses that responded to this survey stated that 20% stated that they are just getting by financially every month. And 25% stated that they are food insecure every month. So this is just one way that the Department of Defense is attempting to work with states to reduce those numbers, which, I think we would all agree it's unacceptable for a family that's serving our country to be experiencing food insecurity every month. So we're hoping that, getting spouses to jobs quicker upon PCS will allow their family to continue to succeed and be financially secure as they move. So I want to move into the recent update. So just looking at the little call out here on the slide, on January 5th, 2023, President Joe Biden signed into law the Veterans Auto and Education Improvement Act. Section 19 of this act contains the Military Spouse Licensing Relief Act, which intends to provide for licensing portability among all 50 states for all service members and military spouse licensed professionals, except for those that practice law. As states implement the provision of the Military Spouse Relief Act, Licensing Relief Act, they can help military spouses maintain professional and financial stability by enacting licensing compacts and ensuring that licensing agencies make their application processes accessible to military spouses. Before I go into what we see as the status of Nevada, so I just want to clarify in the federal law that I mentioned, the Military Spouse Licensing Act, Relief Act, there are two provisions. Provision A requires that states recognize the licenses of a military spouse coming in from another state, period. That is universal. It's the true definition of universal licensure, meaning there's no application process, that they have to recognize the license from another state. Part B gives an exemption for states if they have enacted a licensing compact in that occupation. So if you have a military spouse that comes in, let's say Nevada has enacted I believe the psychology compact. So a psychologist comes in. If there was no compact enacted in Nevada, they would be able to utilize the Military Spouse Licensing Act and basically register with the state and begin practicing right away. That seems to be what the interpretation of the Department of Justice is. That can be tested, and it has been tested. I believe someone asked a question about a recent lawsuit. There was a lawsuit in Texas, and the military spouse was a school counselor, did prevail, and this was a case that was adjudicated last year. And so kind of sets the tone, I think, for interpretation of the federal law. But basically, the court found that the Texas Education Agency did not abide by the federal law and provided an injunction to allow that military spouse to start working right away. But if there was someone that came in and they were to Nevada and they were a psychologist, and Nevada has enacted the psychology compact, then they would just fall under the compact. So then there's some guardrails there. Nevada knows who's coming in. So, I think that there's some pros and cons. But I just want to clarify that when you hear the federal military spouse law, there's two parts. Part A is provide a universal recognition. Part B is an exemption unless there's a compact. So I just wanted to be very clear on that. So in terms of Nevada, from DOD's perspective, and I've worked with the legislature for the past 3 sessions, so I know I've heard that there is an interpretation that Nevada has universal licensure. In our assessment over the last 6 years, we have not found that Nevada's current statute meets what DOD was previously asking, which was a streamlined process for a military spouse to be able to obtain a license. Not an exemption from receiving a license, just an expedited, streamlined process where the spouse, the burden of proof, if you would, to provide documentation and gather, transcripts and proof that they've worked for a certain period of time wasn't on the spouse at the time of application, which added months to their application process. What we found previously in Nevada is that the current statute does provide for what we would call, I'm trying to think of what it's called. I'm forgetting I'm forgetting the term, but basically where you have someone that comes in, they can get some level of portability or reciprocity, but it still requires an extensive process and some requirements. The biggest thing that we found that was a barrier in Nevada were a few pieces. One was that substantial equivalency piece is huge. Like that is what adds the months for a board to evaluate a spouse's appropriate credentials for licensure. Additionally, we found that there were some other requirements in Nevada to include, I believe, having practiced for the immediate 2 out of the last 5 years, and also the temporary license that was provided was what we considered to be too short, which I believe was 6 months. I worked previously with Assemblymember O'Neill on trying to create improve the current policy to kind of get it to where we believe it would truly reduce barriers for military spouses. But then those efforts have not been successful in the previous legislative sessions, and then came along the federal law, right? So we kind of have these pieces now where I think we're shifting. Our focus really is on prioritizing the passage of compacts. The Department of Defense does consider compacts to be the kind of gold standard, if you will, of cross-state licensure, not just one way, but also ensuring that military spouses that are coming and going are able to freely or more easily and smoothly transfer their license to another state. I made a mistake here in the licensing compact, so I do recognize that Nevada has passed 5 licensing compacts. We are not tracking the medical compact. So of the 14 compacts that the DOD is currently supporting, Nevada has enacted 4 of them to include the EMS. So I mistakenly didn't catch the EMS that was passed. So, but we'd like to see more compacts, obviously, being enacted. We really do believe that it's the quickest, most streamlined way for a spouse to get to work while providing the states the guidelines, the guide rails, kind of the guardrails that are kind of what we believe a win-win. And just listing here, the compacts that the Department of Defense is supporting, many of these we've actually funded, as Matt Schaefer mentioned. And I'll add a check mark there to EMS for Nevada. I'm going to see if, I'm sorry, I'm going to go back one. Okay, I already made those notes. So again, I think, we stated that it is important to note that the new federal law expressly recognizes licensure compacts and gives them priority over the other provisions of the federal law. Towards that end, we believe states can best achieve national occupational licensing portability by while maintaining their state sovereignty through the enactment of the compacts. And finally, we can't discuss military spouse employment and economic opportunities without discussing the critical need for families to be able to obtain quality, affordable childcare. Nevada has already implemented our community subsidy program entitled Military Child Care in Your Neighborhood Plus. And we are currently reviewing statute to determine if state licensure exemption for DoD military certified family child care providers who live off base can receive a state exemption from child care licensing, given that they are already certified by the Department of Defense. I have a whole other, I have materials and information about that, but I just wanted to highlight that child care really does tie in to this economic opportunity for military spouses. And so there really is a connection there, and anything that the state can do to improve access to affordable quality childcare for military families is going to help with just part of the puzzle of making sure military spouses can get to work. And just a couple of other points from that survey I had mentioned earlier. So 44% of the spouses that responded to that recent survey stated that childcare is a barrier to their employment. Of those, 54% said that availability was the barrier. 26% stated that quality was a barrier. 34% stated that affordability was the problem. 37% stated that location was an issue. And 28% stated that hours of operation are an issue for them in terms of being able to work and to obtain childcare so that they can work. And with that, I'm going to close it out for questions, and thank you again for having me.
Thank you. Councilwoman Bacchus?
Thank you so much, Madam Chair. I'm really interested in the federal law with the auto licensure versus the compact. It seems like auto licensure is easier for our military spouses. But with that, you made a comment about registering. Can you kind of elaborate like what they do? So they come, I'm licensed in Texas and my spouse gets transferred to Nellis and I go to Nevada and I have like, let's say nursing, like how does that work? Because we don't have a compact here, so it would fall under this auto licensure.
Yes, thank you, through the chair. So it's a great question. I want to again
Ms. Douglas, just go direct.
So Kelly Mae Douglas for the record. I just wanted to reiterate first, the Department of Justice is the federal entity that oversees this law under the Service Member Civil Relief Act. So the Department of Justice has a website with information on that, that court case that happened, on requirements. It has some documents. So I do want to refer you to the Department of Justice first, and I can provide the link. What I will say is that right now, all the states are taking a look at that federal law, usually through their AG office, right? And they're saying, what can we do to implement this at the state level? And what we're seeing is a variety of different approaches. So far, at least in the Pacific Southwest region, for my region, I've seen California enacted policy last year with the express intent of implementing the federal law. And so some states interpret the federal law as you don't have to register at all, that you can come in like Utah's universal licensure provision. Military spouses can come in and work. Nothing at all. If they can get an employer to hire them, that's all they need. They don't have to register or anything. Other states like California with the recent bills that they enacted provides a state license. It just eliminates every other requirement. So basically, the spouse is coming in saying, here's my license, here's my background check, right? You have to have that. And they are given a California license. They did that, yes. Mm-hmm.
Thank you so much for the follow-up question. And thank you, Ms. Douglas. I was wondering, because I know the one thing that glares out to me, because I'm a licensed attorney, is the practice of law was like the one exclusion. But so I got nerdy and I wanted to look. But for those that may be listening to this presentation in Nevada, we have a Supreme Court rule, 49.1, that allows our military spouses to secure a limited license to practice law in our state. And they just have to go through the Nevada bar. So it's kind of nice that we do cover that, even though it's kind of missing in this federal law. So I just wanted to make a comment. Thank you so much for your presentation.
Yes. Thank you. And Kelly Mae Douglas for the record and through the chair. I will say that I know the military spouse JD network, I believe, is who kind of led that effort in terms of working with the state Supreme Courts to enact those rules. I haven't looked at Nevada's rule in a long time. I do know that one thing that they have gone back to the drawing board on, I guess, with the states is if a state had, depending on what limited means, if a state has a lot of them have supervision requirements that are not ideal. And that I know that is one thing that they are asking states to look at. But I'm not familiar with 49.1 here. Thank you.
Councilwoman Torres?
Thank you, Chair, and thank you for the presentation. I wanted to touch on something you kind of quickly covered, I think in like the fourth slide, about the state policy priorities. You hit on some of the education stuff that we've worked on in the last couple of sessions, and I know that we've made some changes for military families as they're enrolling, and then we've also given some priority preference to military spouses that are educators when they enroll here in Nevada. So I'm just wondering if you could give an update on those two different priorities and what challenges and barriers students and spouses that are educators still experience.
Sure, Senator. For the record, Kelly Mae Douglas, through the chair. Nevada has done some things recently that I think kind of move us forward and progress in the area of education. Just, for the open enrollment flexibility, for example, where we're trying to just ensure that military children have the same access to inter-district and intra-district transfer policies. The governor did sign a bill I think last session or maybe the session before, that allows military students to preliminarily enroll in school ahead of arriving if they have a set of military orders that are bringing them to the state of Nevada. And so that was great. And then also, like you mentioned, there was that bill also established a priority for military families that are applying for charter school enrollment. And so one thing that we were looking at doing, one opportunity is to expand that to all schools, not just charter schools, as far as that military priority piece. So yes, ma'am.
So, sorry, clarification, Chair. So is the issue then that it would be exclusive of currently magnet schools? Is that the remaining issue, or where would the issue lie? Because I think we did do the priority enrollment for like your neighborhood schools. So is there an issue then with the magnets?
I think, through the chair, Kelly Mae Douglas for the record, I'll have to double check and make sure I'm right on that. My understanding at the time that I was doing my review of Nevada statutes was that the current priority was for charter schools. So if it's expanded to all district schools, then I will correct that. Thank you.
Thank you. And just another quick follow-up. And then could you hit on the enrollment for educators, and then, inclusive of like administrators and counselors and social workers that work in schools?
So yes, Kelly Mae Douglas for the record, to the chair. I think it was SB 100, something like that, was passed a couple of sessions ago, and we really used that as a best practice when we were working. We had separated out teachers and school personnel from our licensing efforts, just because they tend to fall under ed code or the education statute versus the the labor commerce statutes. And at that time, we did use that bill, which did allow for basically universal licensure for streamlined processing for all school personnel in Nevada. So that was something that we looked at and used as a best practice for teaching. I think now, and that was a good step then. Now we have with the teacher compact that I believe was also signed last session, which was exciting in Nevada. I think it was one of the first one or two states that signed onto that. So with the compact, that kind of for the teachers, that really solves the issue for them. And as far as I was going to say something else, teaching the compact, and then the federal law just kind of comes into that. So that'll be interesting to see, how that is interpreted in Nevada. Thank you.
Additional questions? Anyone up north? So I have just a couple. So I think that what we're doing with the compact, I think that is really good. One of the things that I've always been mindful of is that when we retire, we get, pass and review, and we got all these plaques and things, and our family that supported us during some very perilous times gets a thank you, maybe flowers. So are there any states that, or is there any way that Department of Defense could look at this, and for those that are participating in the compact, set up some type of retirement system for the spouses? Because I think that is really an issue. You have teachers and I use teachers because they're usually the most prevalent, and you go from place to place, but they're never there long enough to get vested in any type of retirement system. So that's the first question.
Kelly Mae Douglas for the record. Yes, Chair. I know that there has been congressional efforts to look at allowing military spouses to access the thrift savings plan, which is the TSP, which is Department of Defense's main retirement system. One interesting thing that I found, one of the attempts was to allow military spouses to roll their retirement into their spouse's TSP, which was not a successful effort, and probably for a lot of good reasons. I know for me, I have a TSP, that I transferred all my education experience, all my education years into when I joined the federal service. So it was really a benefit to me to have my own TSP. But so of course, like using someone else's TSP, I don't think has been found to be a viable option. I also believe that there's been other efforts through Congress to somehow kind of, I think to your point, Chair, create some sort of way for a military spouse to have their own established TSP that could be fed into as they move from state to state. But as far as I know, none of that has really come to fruition and hasn't been met with success. But to your point, I mean, again, I was a military spouse teacher. I traveled, across the country and the world and taught overseas and, taught in 7 different systems and had 7 different retirement systems. So, having finally decided to move into federal service, it was really beneficial for me to consolidate it all into one spot. But I know that that's a challenge for those that aren't in federal service. So, I recognize the concern.
And I think it was 2019, we did a Senate Joint Resolution, I want to say it might have been 6, urging Congress to do that as a way. So if there's anything that we can do, if there's something moving around in the system right now, if there's anything that we might be able to do, I'd like to hear about it and see how we might be able to support it so that we support our military spouses.
Kelly Mae Douglas for the record, and thank you, Chair. I have seen a couple of different approaches from different states, such as Utah. I think recently they're stated that they're looking at one approach next year in terms of when a military spouse is working in the state, that they can get automatic vesting before they leave. So at least they have something to transfer, right? So I know that's not everything. And we will take a look at what other states are doing in terms of approaches that I think, because at the end of the day, there's a congressional, there's a congressional approach that can be taken, which hasn't been successful yet. But there are also things that I think states can do, and we just need to brainstorm and think what are some ways that could get to that. Maybe not one answer, but a kind of a group think. Process where we put together a variety of approaches. So I'll share, I'll go back to my team, I'll go back to my leadership and see if I can share some best practices.
Yeah, I appreciate that, because even if they get vested in Nevada and they get vested in Ohio, it still might not be enough, if you will.
Yes.
So, yeah, think about that. I think Senator O'Neill has a question.
Yeah, thank you, Chair. I didn't wave at you fast enough. Ms. Douglas, I appreciate you coming here, particularly coming in person and presenting this today. I may be putting you on the spot, and I apologize, but you mentioned 2 bills, AB 439 and SB 402. You didn't mention what session they came out of, but I think that's probably 2021. Do you know why those bills failed to be enacted? And that's the part that may be putting you on the spot.
Yes, Assembly Member, through the Chair, Kelly Mae Douglas for the record. No, yes, that is putting me on the spot, and I don't know. I don't know the answer. Working with you, I believe, on at least the first version, we believed it was a pretty simple, common sense solution.
That's what
so
killed
not
it.
really
As
sure
soon as you
why.
say simple
Yeah.
bill, that's what kills it. There is no such thing. We never use that again. I was just curious because I didn't remember either. That's why I was hoping you, and 2021 is correct, is it, session?
I think so Kelly Mae Douglas for the record. I believe AB 439 was 2000, yeah, I think it was 19 and 402 was 2021.
Okay. I appreciate that. I didn't mean to put you on the spot like that, but I was just hoping you could refresh my memory too. So thank you. Thank you, Chair.
Not a problem. And Mr. McElhenny just reminded me in 21, we had Senate Bill 402. It was an omnibus bill, and what we were really trying to do was make sure that there were a number of areas that were covered, and it would include military spouses. I thought it was a pretty good bill, but we couldn't get anywhere with it. But maybe the Assemblyman is correct, so maybe we'll come up with an uncommon or non-common sense solution. So I have one more. So in 2015, I sponsored a bill to give priority placement to military children of military families, especially Gold Star families, and we couldn't get it out of the Senate for some reason. And so you had child care there as, one of the, and I consider all of these readiness issues, because if you're stationed, at Nellis, but you work at Creech, and you're a single parent, but you don't have child care, and your child is sick, that's an issue. Are we looking at anything like that, some type of a blanket priority placement? And I think even if we couldn't get it for someone else, I think Gold Star families deserve it. And for those who are not familiar with the term Gold Star, those are families who have lost a loved one, been killed in combat. And so anybody who has paid the ultimate sacrifice, I think that's the least operative word, least that we could do for them. So I'd be interested to see if there's anything we can do for priority placement of them. It's particularly, and we had a Gold Star mom to come and testify. When the chaplain knocked on her door, she didn't want to answer. She said, I don't want to go. I don't know. And it took her a couple of weeks to really find her footing. But she's got 4 kids, and she's trying to, when is the body coming back or whatever, and that sort of thing. So if there's a way that we can kind of look at that, I think that would be, helpful. Okay. Last thing I was going to say, there was also the undersecretary, I think, sent a letter to all of the states in 21. I think we talked about that. And BRAC, and a lot of people aren't familiar with BRAC. So can you just talk a little bit about what that means, base realignment and closing? What does that mean? And if there are any implications in terms of the economy, not just now, but what would that look like in the future if they wound up on the BRAC list?
Thank you, Chair. Kelly Mae Douglas for the record. I will say I don't want to get too far out of my lane. As you know, there are lanes in the military, but I will say, I can speak to going back to my point about the National Defense Authorization Act that requires the military services and the department to consider certain quality of life initiatives in their mission basing processes. When I say mission basing, that does also include base realignment and closure. But we tend to now speak about the more global decision-making process that the department goes through, which might include BRAC, might include closing realignment, but also includes the consideration of additional missions at a base or taking away a mission from a base. So in terms of ramifications, I mean, any change will result in either an increase of service members and families that are stationed here, or a decrease, right? And so, and that's the reason why we are required to consider these family type issues, because the department doesn't want to send military families to a community that doesn't support them. And so, if it's harder for a spouse to get a job, if the military children don't have access to the existing programs that other children have access to, then that is part of the consideration. I'm not saying that's going to bar, some sort of assignment of certain service members to the state, but it is a consideration, and that's why we do consider that. So obviously, with less military missions, if that were to happen in a given state, then there are impacts to the economy, right? Because the defense community brings in millions and millions of dollars to every state's economy through contracts, through direct, payments, through taxes, and et cetera.
Thank you. Committee, additional questions? Up north? Well, thank you so much, and I hope that your trip to Las Vegas was worth it.
It really was. Thank you, everyone.
All right, thank you so much. So we're going to go now to agenda item number 6, presentation of the Dentist and Dental Hygienist Compact. We have Matt Rossetto, Legislative Liaison for the American Dental Association, and Matt Schaefer. I think we just heard from him too, so there we go. Who's going to go first, Zoom or?
I'll start here up in the north.
Okay. All right, thank you.
Good morning, Paul Klein with Tri-Strategies. I'm here on behalf of the Nevada Dental Association, and we appreciate the opportunity to come talk about the Dentist and Dental Hygienist Compact. A couple things to note before I pass it over to the Matts is specific with this compact, something to note is the in-depth and elaborate development process that was done to get the language together. They really brought in a lot of stakeholders and really dug in to get it to a place where a lot of people felt great about it. And that's why I think specifically with this compact that may be different from other compacts that you've considered is why the workforce supports it. And with that, I'll turn it over to Matt Rossetto, who is the legislative lead for state governments with the American Dental Association. I'll be here to take notes and available for any follow-ups or materials that you may need or want after the hearing. Thank you.
Thank you, Paul, and thank you very much, Madam Chair. I appreciate it, and the members for your time today. As was mentioned, my name is Matt Rossetto. I work at the ADA in our State Government Affairs Department. I help our states out with legislation and policy with regard to workforce in a variety of areas. One of those is certainly the Dentist and Dental Hygienist Compact. Madam Chair, before we begin, I wanted to directly address a couple of the points that you brought up earlier with regard to workforce and the question of, do we know where folks are coming from, what's portability like, and all of the rest of it. The good news is that the ADA has done some real work on this recently, trying to identify trends and patterns and what's going on. So I'll start by mentioning that the research that HPI, our Health Policy Institute, released tells us that upwards of 15% of dentists will move their state of practice within their first 5 years. That's a level of mobility that we have never experienced in the profession before. And so this is one of the reasons that the ADA is so passionately committed to this compact, simply because you all are familiar with the term of people voting with their feet. Dentists and hygienists are doing the same thing. And so this is one of the ways that we can support our members, our young members and our students who are just about to come out of school. They are doing the moving. And if we can make it easier for them to continue their profession and, ease the continuum of care for the patient, we believe this is one way to do that. And you asked about, can we track where dentists are going and where they're coming from? We can actually do that, and we can do it state by state. So I have the numbers here for Nevada specifically. And I'll start over here on the right, and I don't know how well you all can see this, but Nevada is one of the states that from 2019 to 2022 did see a net drop in the number of dentists overall, and that was a reduction of about 2.9%. And we can tell you where dentists are coming from and where they're going to. So if they left Nevada, most of them, top 5, went to California, Texas, Florida, Utah, or Oregon. And if you're looking for, if they're moving to Nevada, where are they coming from? California, Texas, New York, Arizona, and Utah. So none of those are huge surprises, but this is something that we just wanted you to know we are in fact actively tracking. And this helps us, respond policy-wise to what's going on at the national level and certainly at the state level as well. I'll begin our presentation here as well by doing this.
Hold it just a minute. Can you
Yes,
do me a
ma'am.
favor? Because we don't, the link to the fact sheet, I don't think we have it. Can you
Yes.
send that to us so we can follow along, please?
I will absolutely send that to you. Yes. Of
Okay,
course.
thank you.
Of course. And that's a resource that is customizable by every single state. So that's something that HPI will update regularly. So we'll start with the dentist and dental hygienist. Excuse me. We'll start with the dentist and dental hygienist compact here. I don't know why it's telling me my screen sharing is paused. I'm sorry. Okay. Show from beginning. Let's do that. There we go. Dentist and dental hygienist compact. So Paul mentioned the development process. And so I just kind of want to walk you through that so you know how we got here and why we're here. So this has been under discussion in dentistry for some years, but the first major meeting of stakeholders that happened on this took place 5 years ago in 2019. This group was convened with the help of CSG. That's a lot of acronyms up there. I'm not going to go through all of them, but suffice it to say that's the dentists, the hygienists, the dental students, dental educators, dental support organizations, the dental boards, everybody that you would expect to be in on a good comprehensive compact for the profession as a whole. The general consensus from this meeting was that dentistry should continue to talk about going down this road. Obviously, 2020 happened, that slowed down the development process, but when this was picked back up in 2021, the ADA and the American Dental Hygiene Association officially responded and applied for the creation of a compact. We were accepted later on that year. There were obviously several other supporting organizations, as we note there as well. So after that, Matt mentioned this earlier, this is a real life example of what a technical assistance group does. This was a group of roughly 20 stakeholders from all over the profession, dentists themselves, board members, educators, staffers at the ADA. In over 3 months, they basically took every major idea that should be in a compact and put it into plain language. There were representatives from a number of different state boards of dentistry contained within this group, and those are all listed there. The next step in the development process was what's called the document team, and that was taking the plain language and, much like your drafting attorneys do for all of you, turning it into legalese. This was the attorneys in addition to a smaller subset of folks who were on the other team and representatives from 3 dental boards that took the plain language, turned it into an actual draft compact document. In the fall of 2022, the initial draft was circulated for review. This was not done just to stakeholders. This was done to the public at large. This was a comment process that was available to anyone. There were weekly public meetings where the compact was done section by section. Internally at the ADA, staff went over this several times with state staff, executive directors, all of the rest of it, so that we could gather their input and their thoughts. During that 8-week public comment period, we received over 400 sets of comments. Based on those comments, adjustments were made to the draft. And then in January of 2023, the compact was finalized, made public, and made available for states to consider introducing, consider introducing as legislation. Before we move on, I want to just very quickly recognize my colleague from the ADSO, Matt Steele, who wanted to make a very brief comment and introduce himself and his organization participating as well.
Madam Chair and members, thank you so much for a quick moment just to jump in today. My name is Matt Steele. I'm with the Association of Dental Support Organizations, one of the stakeholder groups that Matt Rosetto mentioned. Just wanted to jump on real quick and state our support of this. We have 330 plus supported dentists in Nevada, over 120 practices throughout Nevada, and we support over 480 hygienists in the state, with a total patient flow of about 1 million patients. Most of our offices are scattered throughout the state, but we're particularly interested in this legislation because we would love to expand to areas that access to care is experiencing some challenge right now. And so we've been working in other states. We're excited about the prospect here in Nevada, and just wanted to come on and say that we're excited to work with you here in the upcoming legislative session. Thanks, Matt.
Thank you, Matt. And I'm now going to pass it on to my colleague from CSG, Matt Schaefer, and he's going to go over some of the more technical elements of the compact itself, how the actual ins and outs of how it works. And then at the end of his presentation, he and I can stand for any questions from members of the committee.
Thank you, and good morning again. Pleasure to be addressing the committee once again, this time specifically on the Dentist and Dental Hygienist Compact.
Excuse, just a minute. Matt, for some reason your volume is a little low. I don't know if that's on our part or can we fix that though?
Sorry, is that any better?
It's better.
Okay. Sorry, I think my microphone was just below my my face a little bit there. So thank you again for the opportunity to address the committee, this time specifically talking about the Dentist and Dental Hygienist Compact. And hopefully based on the other speakers, you'll be able to see how widely this is supported amongst dentistry. We have all sectors of oral health really in line here on the need for the compact, which is unique. A lot of times you will see dentists and hygienists on the opposite side of issues, but this time there's really a unity around the need and a purpose for this compact. So I'm going to talk a little bit about the technical aspects here, how it actually works from a functional standpoint. So the compact operates on what we call a compact privilege model, where the dentist or hygienist holds a active and unencumbered license, and they apply for what we call a compact privilege. So this is essentially just legal authorization to work in another state that's a part of the compact where they do not hold a license. They undergo a FBI background check, and their eligibility is verified based on some criteria I'll share on the next slide. They'll pay fees to that remote state where they are applying to work and complete any necessary jurisprudence requirements. So if Nevada has a requirement that all dentists have to pass a laws and rules exam or some sort of the Nevada statutes assessment, they would have to complete that requirement, and then they would be able to receive that compact privilege. Now, to the previous agenda item where I spoke, we talked about how compacts alleviate the need for this application process, and you can start to work right away. I do understand this is a little bit to an extent of a application process and a verification that the person is in good standing. But the thing I would emphasize here is that the time savings associated with using the compact versus the traditional licensure route. So all of this, because it's streamlined through the compact data system, takes a matter of minutes. Your eligibility can be verified in just a few clicks of a button. And so you're moving from a scenario where you're waiting on a licensing board to make a determination, as we've discussed, that takes weeks, sometimes months, to a scenario where essentially you're just checking the box. Here are the states where I would like to work. We make sure your license is in good standing and you meet all the criteria, and that happens in a streamlined manner through the compact's data system and can be done. The PT Compact says on their website they can issue a privilege in 10 minutes, so much faster than going through the traditional route. On the next slide, we'll talk about the requirements to actually participate in the compact. So you have to have a qualifying license issued by a state that's in the compact. We say that is an active and unencumbered license. So if you have any kind of disciplinary actions or any kind of your scope of practice is impeded at all, your ability to use the compact, you would not be able to use the compact until your license is restored to good standing. You're fully unencumbered. There's examination requirements. There's a national board exam that all 50 states require for licensure, so that's included in the compact. You have to have a degree accredited by the accrediting body for dentistry programs, and that's called CODA. successful completion of a clinical assessment. This is a test of your clinical skills. Again, all 50 states require a clinical assessment for licensure. So these are standard requirements that Nevada and all the other states already have in place. And then lastly, I mentioned the point around criminal background check. That is a requirement for the compact as well to pass a FBI fingerprint-based background check. A lot of these benefits are going to be the same to the presentation that I gave on the previous agenda item, but obviously primary benefits here talking about mobility, ease of mobility when you want to practice in multiple states. Maybe you don't want to change your residence, but you just want to work across state lines in a neighboring state. Also facilitates mobility when you're actually picking up your practice and moving to a new state, which in turn expands your employment opportunities. Kelly May did a great job of describing the military's perspective on this issue, and then just generally reducing the burden of maintaining multiple licenses. We're talking about reduction in CE that's required, paying duplicative licensure fees and things like that. So really for the licensee, there's significant benefit. For the boards, I've talked about how compacts have this shared data system that's in place, sharing things around investigations and disciplinary actions. The compact just generally is a vehicle for boards to cooperate across state lines around investigations and disciplinary matters that may be occurring in multiple states. And the compact empowers the boards to work together collaboratively across state lines. And then just generally for the state, we've talked about how this is a workforce development tool and simultaneously reduces barriers to employment while preserving state sovereignty over the Dental Practice Act when licensees are within Nevada's borders. I want to talk a little bit about the Compact Commission. This is something where there's a lot of kind of misunderstanding and misinformation about what this body is. So the compact is not owned and operated by CSG or the ADA. This compact belongs to the member states that have enacted it. And the governance structure that's set up through the compact is called the commission. Every state that passes the compact gets to elect one person to sit on this commission. We say it's a member of the state licensing authority, so it'd be a member of the Nevada Dental Board. And the compact creates rules and procedures to help the compact function properly. What cannot happen is there could never be a commission rule that impacts practice specifically in Nevada. There can never be a commission rule that goes outside of the bounds of what is specified in the compact, and that's essentially just how do you get a compact privilege. So anything outside of that is off limits for commission rulemaking. We hear kind of these questions all the time about, well, is the commission going to be dictating things to my state about how practice looks? And the answer to that is unequivocally no, that the commission is not authorized in any way to do that. Really, their only purpose is just to facilitate and administer the compact, and rules are limited to that. Only people using the compact would ever be impacted by a commission rule. So just wanted to make sure there was clarity around that point. A couple other things to emphasize. This, again, is just an additional optional pathway, not a takeover of how dental licensing is done in Nevada currently, but just a new pathway. This privilege model is utilized by a number of other professions. I think psychology and PT probably most closely aligned with what dentistry is doing. And I know Nevada is a member of SIPACT. We don't believe there's a significant cost for the state to participate. There could be some cost associated with making sure the Nevada board can interface with the compact's data system. But beyond that, there's really very limited cost in terms of state participation. And again, just want to continue to emphasize that the state retains control over their Dental Practice Act and also discipline of practitioners within their borders. So if somebody comes to Nevada, violates Nevada's laws and rules, they are subject to the Nevada Dental Board, and the Nevada Dental Board can take an action on their ability to practice in Nevada. This compact will be active when 7 states have enacted it. It is brand new. This is one of these compacts that we developed in cooperation with the ADA through the Department of Defense program that Kelly May mentioned on the previous agenda item. So on the next slide, we do have a map that shows where we're at currently with legislation. So you can see there, we have 5 member states. That's Washington, Wisconsin, Iowa, Tennessee, and Virginia. And we have a number of bills moving through the legislature at the moment. We do anticipate we will hit 7 states probably in the coming weeks. We have bills on governor's desks at the moment awaiting signature for enactment. So very confident that we'll get 7 states this legislative session. And with that, I will stand for questions. Again, thank you for your time, and thank you again to the chair. And we'd be happy to address any questions from the committee.
Thank you so much. Committee, questions? Okay, Assemblywoman Kasama.
Just a comment, I think these compacts are so important. My older daughter is a dental hygienist, and she was looking at perhaps relocating down here. And I can't say this is the only reason, but she decided not to because, it's going through the regulation again after she spent so much time in Washington State. And it does become a barrier for people, moving. And all of our states, we're short of healthcare workers in any occupation. And so I'm certainly supportive of trying to help with the easier movement and supporting our healthcare workers as they move around because I lost having 2 grandbabies come down here too. So very important to me.
Additional questions? Got anybody up north? Questions? Assemblyman O'Neill? No questions? Okay. All right. So, she's not here today, but in the building, but Senator Ratty was the one that got us started on making sure we had dental hygienists here in the state, and boy, she took a beating for that. So I just want to thank her publicly because, we're on the road, and thanks a lot, Senator Ratty. So I don't have any questions. So with that, we want to thank you all for coming and presenting.
Chair,
look forward to...
Chair, can Ms. Soley just add some comments on behalf of the Northern Nevada Hygienists Association?
Sure.
Good morning. For the record, I am Karen Soley. I'm a registered dental hygienist here in Nevada, and I'm the co-chair of the Nevada Dental Hygienists Association's Government Affairs Committee. I thank you for a few moments of your time. I did submit prepared statements, but because of everything already being so succinctly covered by the 2 Matts and Paul, I'd like to take just a moment and maybe share a little bit of the fact that the American Dental Hygienists Association has had policy regarding portability of licensure for over 25 years, and the Nevada Dental Hygienists Association in 2001 created policy here within our state association supporting portability of licensure, and we reestablished our support for that in 2013 and again last year. I do appreciate the fact that ADHA, the American Dental Hygienists Association, worked really hard in connection with all of the groups that crafted this compact agreement and are bringing it forward. I'd take just a moment to maybe point out a couple of quick little things from a personal standpoint. I have had to, in my 53-year career, take licensing examinations and do licensing requirements in 5 different states. And in that time, some of those opportunities created a great bit of challenge in the form of I'd moved to a state in October, and they only gave their licensing exam in September. So for 11 months, I could not be employed. My family had lost income, and the state lost revenue, but more importantly, there was patient care hours that were totally wasted and lost. So being able to have an opportunity to move to states more readily and provide care is truly something that is really, really important. The cost to take the different licensing exams was very expensive, even though some of them were back in the day, even now, those things take a lot of time. The Nevada Dental Board takes a bit of time issuing licenses, so to have something be much more rapidly available is just so critical. And so I ask for your support, and I also am available to answer any questions. Thank you.
Thank you. Committee, questions, comments? Did I understand you say 53-year career?
Yes, Madam Chair. I just retired in December, but I still keep getting called back to my office to work. I'm still getting in about a day every 2 weeks.
Okay. Well, thank you so much for your service. Thank you so much for your service. Okay, Silverman O'Neill?
Yeah, I have one question. We currently, though, have the ability to recognize licenses from other state. The dental board does, correct? But they have to go through, if they're already licensed in another state, they can apply for the board here, but they have to go through all the testing all over again, or can they just be recognized?
Karen Soley, for the record, if it's all right if I take this to answer, I did serve on the Nevada Dental Board for two terms. And yes, there is a mechanism, but again, it's timely. They have to submit all of their data, and it has to go through the committee and then to the full board. So it really typically is several months long process, if not more. Did I answer your question correctly?
You even answered my second question of how long a time period. Several months could be defined as, during your term, what was several months?
Well, when I was on the board the last time in 2013 to 15, we did try very much to expedite it, and we were trying to have a turnaround of once everything had been received in the office for the application process, and the staff had guaranteed and authenticated it all, that it would come to the board and that they would have their license back to them within 2 to 3 weeks. Since then, I know the dental board has had a lot of staff turnover and staff shortages. I anecdotally, this last summer, received questions from probably 5 or 6 different entities, different applicants from different states, as well as from recent grads, that it was taking anywhere from 2 to 4 or 6 months for them to get their license.
Ms. Soley, thank you for the information. Thank you for your service, too, on this important topic in our dental hygienes. Chair, I appreciate the time. Thank you.
No problem. That's what we're here for. And so I want to thank you all. So we're going to move now to agenda item number 7. Presentation on the Board of Examiners for Social Workers and the Social Work Licensure Compact and the Association of Social Work Boards Examination Disparities and Pass Rates for different demographic groups. Very interesting. Presenters, we've got Vicki Erickson. And we also have for the ASWB, Dr. Stacy Hardy Chandler.
Thank you, Chair Spearman and members of the Joint Interim Standing Committee on Commerce and Labor. I have a prepared statement. For the record, my name is Vicki Erickson. I'm also a social work licensee in the state of Nevada. I'm the executive director of the State of Nevada Board of Social Work Examiners. First of all, I would like to thank the committee on behalf of the social work industry to allow me to present today. We have seen significant interest in identifying opportunities for the industry of social work to expand, and we do appreciate that support. The board and the Association of Social Work Boards have an excellent working relationship. We appreciate the partnership and working through any unforeseen issues licensing social workers in Nevada, but also identifying potential opportunities that strengthen the industry and streamline the path to licensure. And looking at the presentation you will receive from the association, we agree that the data is accurate. The only differences in this data that I want to note is the presentation indicates there are about 4,000 licensees in the state of Nevada. However, as of this month, we are close to 4,700. First, I do want to thank Assemblyman O'Neill for an emergency bill last session. It did not move, but we do remain grateful for that. Looking ahead to the 2025 legislative session, the board and the association both are in support of the proposed interstate compact for social workers. As of today, there are 4 states that have adopted the compact, including Utah. Please refer to the map that was submitted to the committee staff. When the compact reaches 7 states, the compact will go into effect. It is then that the process begins of setting up the Social Work Compact Commission, which includes putting together a database of licensees. This process will likely take roughly a year to stand up. I also wanted to bring to the committee's attention that the Joint Interim Standing Committee on Health and Human Services will be hearing from the Council of State Governments regarding the Social Work Compact on Monday, April 8th. We applaud the significant interest in social workers and request today, as we will request on Monday, a bill draft request for the Social Worker Compact leading up to the 2025 legislative session from either committee. Thank you for your time, and I would also like to introduce Dr. Stacy Hardy Chandler, the CEO of the Association of Social Work Boards and also a Nevada social work licensee.
Thank you.
Dr.
Can you hear
Chandler?
me?
Yeah, we can hear
Yes.
you now.
Okay, thank you. So although I am not coming from Nevada, as Vicki mentioned, I am a licensed clinical social worker in Nevada. I'm Dr. Stacy Hardy Chandler. I am also a former faculty member from UNLV and also a graduate of the Boyd School of Law. So I come to you honored to have this conversation and to share this information on behalf of the Association of Social Work Boards. To move forward in the PowerPoint, I just want to start with a quick overview of what ASWB is. It's an association of boards, just like there would be associations for medical, for dental, for nursing. So we support the Nevada Board of Examiners for Social Workers, as well as the boards in all 50 states, U.S. territories, and Canada. So I'd just like to emphasize what our role is. It's in service to relieving some of the burdens of the boards that provide the licensure regulation. The focus of my presentation here is about accountability. ASWB has to report up to its board of directors, which is elected by all of the state and provincial boards. And we're all accountable to the public. And that's an important piece because as we talk about the examination, it really is a tool of accountability. By the way, I'll go through some of these slides a little quickly because I know I have a lot of them, but I will welcome questions at the end. And I would also like to offer to come back to the committee at the committee's request if that's necessary. Moving on, I just wanted to highlight why social workers are licensed. That might be evident to some and it may not be evident to others, but it's really about upholding the confidence and trust of the public. That when someone is getting a licensed social worker, that the public knows what that means. I don't think that there's a social worker who hasn't heard someone say, well, I'm like a social worker. We want to make sure that the social work profession, its status, its knowledge base is all upheld. And as it's worded in the Nevada law is perfect. The practice of social work is hereby declared a learned profession affecting public safety and welfare and charged with the public interest and is therefore subject to protection and regulation by the state. Perfectly captured. I've included this slide for a number of reasons. The main reason is that when we think about human services, particularly what might come to mind is counseling or psychology. What differentiates social work is that each step is its own distinct category of practice. So you can practice as a bachelor's level social worker. You can practice as a master's level social worker. You can practice as a clinical social worker. In some other professions, the majority of people who enter them are on a journey to become the clinician, a clinical social worker. or a clinical counselor, whatever the category might be for that discipline. In social work, that is one category of practice, but other social services beyond mental health are hallmarks of the social work profession. And this is just a quick snapshot of licensure in Nevada. And I just wanted to move on to the various categories of licensure in Nevada, which honors the fact that social work has different categories of practice and not, sometimes it's been characterized that the master's exam, for example, is a stepping stone to the clinical. And that's not always the case. You have social workers who practice as master's level social workers for their entire careers. And that's completely valid and legitimate in our profession. I've had to highlight in other spaces that social work is a profession. And by virtue of being a profession, want to bring your attention to that bottom box that regulation is responsible for verifying minimum competence. And so that really speaks to why an exam is important. It is critical to regulators in meeting that mandate, fulfilling their duty as regulators to verify that minimum competence. So that being said, just like other professions, we follow standards that guide how tests are developed for licensure specifically. And these are global standards that, again, are the same standards with some variation that are followed by nurses, OT, psychology, and other health and human service disciplines. We believe that the best combination of factors for social work regulators to make regulation decisions for licensure issuance include all of those factors: education, the exam experience if it's necessary, which is the case for the clinical level. Most states have something regarding moral character or a criminal background check or something to that effect. And all of these provide regulators information to make these important decisions. And I'll say for social work, we are charged with serving the most vulnerable populations. So these decisions are very critical. It's no accident that the board is called the Board of Examiners for Social Work, because that examination piece is the part that regulators oversee. They get transcripts from schools, they get reports from supervisors about the experience, but the part that speaks to what regulators oversee is the exam. So let's talk a little bit. This is a statement by an attorney who works with a number of associations, basically talking about how exams are core to the regulatory duties that boards have. This emphasizes that those standards require that examinations be valid, reliable, and comply with their structure. I often ask people how many staff members do they think write the exam from ASWB? And whatever number you have in mind, the answer is 0. So sometimes the misconception is 2 people at ASWB are writing these professional exams. That would not comply with the standards. Professional examinations are driven by members of that profession. And by the way, I'll say the exam as if it's a singular thing. But there are, again, different categories of exams. There are different forms that are equivalent of the same exam. So it really is more of an examination or a competency measurement process than a single exam. And so this just highlights that there are typically up to 200 people who are involved in the exam development process. The staff at ASWB shepherd that process that is driven and led by practicing social workers. The people you see on this slide are consultants. They're critical in the examination development process, and I'll talk about their role in a minute. But everyone else, other than providing the administrative structure to make sure this happens, everyone else is either a volunteer from the profession or an external vendor or an item writer, and they're external also. But social work is one of the few professions that compensates their item writers, even though they're not employed by us, for producing items. I do want to highlight that we pay attention to graduation rates for our profession, and you'll see it's a little hard to see in this graphic, but the purple line, those are our item writers, and the other 2 lines are graduation by demographics from social work programs. So we try very hard to have our item writers reflect our profession, not only in terms of these demographics, but in terms of geographic location, in terms of areas of focus. So they are a very diverse group. So this is very important to highlight because any competency exam for licensure starts with a practice analysis. It starts with a survey of the profession. And the group that you see here are volunteers who oversee that part for us. So right now, a practice analysis is happening. Every 5 to 7 years, we survey the profession to say, what is it now that social workers need to know as they enter the profession? Not specialization with particular groups, not working in particular settings, but on day one in any setting, what does a professional social worker need to know at whatever exam level it is? So we certainly want to encourage all social workers to respond to the census that is out now, because you can have some input on the next iterations of competence measurements. The exam writers, I said, are practitioners, and we have them on the website, and you can see their background and their locations. Their integrity in what they do is phenomenal, and they're just a phenomenal group of people. The other people I want to introduce you to are the exam committee. And these are people who are another layer of checks and balances through the exam development process. They too are diverse in terms of area of practice, geographic location, demographics, and everything else. So you've met a lot of people. I'm going to put together where they play a part in exam development. So exam development, I think people sometimes think about maybe a test they might have put together for a class they taught, or what they think might happen at, let's say, the university level. But the standards require a much more involved process with many layers of checks and balances for anti-bias integration into how exams are developed. So it starts with who's writing the items. And again, these are social workers who are out in the field. There's a call that goes out. And again, they're selected in order to represent the cross-section and the diversity of the social work profession. They're taught how to write exam items, how to write them clearly without microaggression, and to leave out all of the jargony words. The reading level of the social work exam is about 10th grade. It's not reading comprehension, it's about decision making. And so that's a special kind of writing. So they get that experience. Moving to the middle column, they start to submit items, and they go to those 7 people you met in the beginning, the consultants. These are experts in licensure exam items. They review them. They decide whether or not that item is going to move on to the next step. They also provide feedback to item writers that help them in their growth and development. And then if the consultants move the item on, it goes to that committee that you met for that category of practice. And if you have an opportunity to observe an exam committee, this is the equivalent for us. It's the equivalent of what nurses call a sensitivity committee. They review each and every item. Ego is left at the door, and it really is about the clarity of the exam to produce what the exam is supposed to do. When they review each and every item, they also make sure that all of the items link back to the social work literature and research. So items can't just be what Stacy wants to put on a test. It has to link back to what the field is saying in that area. So all items have citations in the social work literature. After the exam committee, it goes into the psychometrics phase. So all test items have to be psychometrically monitored for how they perform. Are certain demographic groups performing better on an item or worse, or what's happening with that? If it's uniform across the board, we call that good statistics. And then finally, that item will make it on the scored side of the test. It can be, if it doesn't show good statistics, it can be deleted or sent back for revision, but most often deleted. So I know the time is limited, but just to sort of recap about the exam, since that was one of the questions. There's 170 items at any time on any form of the exam. 20 of those items are mixed in and they're pre-test. Historically, excuse me for a second. Historically, the items had 4 options. We only have a multiple choice structure. There are some licensing exams that have different kinds of structures. We are phasing in a 3-option multiple choice, and that was a data-driven decision. People just simply weren't choosing that third wrong answer. It wasn't helping or hurting them. So with the same period of time. And there's a universal pass score. So I listened in on the discussion about the compact. The test is exactly the same if I pass it in Nevada versus where I am now in the DMV area, the Washington metro area, or British Columbia. Same passing score. So that helps with the portability. And just for the sake of time, moving on, there was a question about what's on the exam. As I mentioned earlier, all exam questions have to be built on that blueprint that comes from the practice analysis, which is the survey of the profession. So the outlines from the past practice analysis are available online. You can certainly review those content areas, and a new blueprint will be developed out of the current practice analysis that's happening right now. What do the questions look like? They are written with limited information, and the person has to choose among the available answers. And there usually is a prompt like, what would the social worker do next? Or what is the best selection under the circumstances? So the amount of information varies. But again, remember the objective of the test, and that is, what should any social worker, regardless of specialization, regardless of what school they went to, regardless of populations they want to focus on, just on day one, what should any social worker know? So the request was made for the pass rate information for Nevada. And by the way, the pass rate information for all states is available online as of 2022. Our board of directors made and let's think about the timing. There was a lot going on in terms of understanding diversity and equity, and our board of directors in 2021 voted to make the investment in an analysis that disaggregated the data so that we could understand pass rates better and have conversations like this about what's going on with various groups. So here are the pass rates for Nevada. I just put a little box at the top for the national first-time pass rates just by comparison. You're doing a little bit better in the clinical exam, a little bit worse than the national numbers for the master's exam and for the bachelor's exam. So I mentioned 2022 and the investment that our board of directors made. They had an external independent psychometric group produce a report with disaggregated pass rates by race, by age, gender, whether a person spoke English or not, as a preliminary look at what might be happening in terms of access to licensure. So we also produced an interactive map, so you can go on that map and see how the state is doing with that breakdown. And we also had that company produce reports for all 800 social work programs across the United States and Canada. So this was a major investment in starting this conversation. Social work was the first health or human service association to publish disaggregated data in this level of detail. So here are the pass rates by state. In the processes, you can look at pass rates and do it by the last 4 years or the last 10 years. And if you hover over Nevada, you'll see this breakdown by race, by gender, by age, and by language. And this is part of why I'm here to have this conversation. People are not passing across demographics at the same rates. We have people of color who are not passing the exam at the same rates as their white counterparts. And this is an important conversation to have. With all of the safeguards and all of the anti-bias measures in the exam, we know that people don't come to the exam with the same access to opportunities, the same experience, the same history. This is Nevada, but of course, we have the information for the whole nation. And when you dig a little deeper, you see differences by school. You can see places where schools are producing people who actually graduate the same across different demographics. And then you have other schools where there are humongous gaps. So this research is just starting, and we need to understand more about what is happening in different areas. Certainly, certain regions of the country also have lower pass rates. So the pass rate gaps are bigger in the southeast, and they get smaller in the northwest. And these are a lot of things that we need to understand. You asked for more Nevada information. There are 2 schools of social work. I taught at the University of Nevada, Las Vegas. In its School of Social Work, you see the pass rate data here. They are not the same by Nevada or versus UNLV. Again, this is just a snapshot. The full reports are available. But again, I want to caution that there are a number of factors that impact this. And one of the things we want to be an active part of is understanding how people come to the exams and how they can best demonstrate their competence. We recognize that we are part of a larger system. So we're very committed to working with educators and working with researchers in getting some of these contextual questions answered. That does not mean just because there are systemic and institutional factors impacting these disparities, that does not mean that there isn't work that we can do from the regulatory space. So I just wanted to highlight in the remaining minutes some of the things that we as regulators are doing from our part of this larger system to address this systemic issue. And that is, first of all, providing free exam resources to educators. We get everybody from people saying, licensing was discussed often as part of my educational experience. And we get people, and this is anecdotal, we get people who say licensing was actually never mentioned in my program. We have schools we know where there are faculty members who are licensed and others who are not. It's unlike, let's say, medicine, where all of the doctors who teach have to be licensed. That's not the case in social work. We have an array. But one of the things we want to do is make sure that educators, wherever they are, have access to accurate information about the exams, about licensure, so that they can share that with their students. We also recognize that there is a lot of misinformation about regulation out there. So we created an exam education series where we talked about all of the aspects of the exam. We invited educators. We had hundreds of people show up. It was targeted for educators, but we did not include any other people who wanted to attend those. And those recordings remain available online to everyone to view because we think there is a huge need for regulatory education. Internally, we are re-envisioning parts of the candidate experience when they go to take the exam. How can we improve that experience just contextually? We know people are nervous when they come to exams. How can we make that better? But at the same time, how can we safeguard the security of the exam? So a lot of things going on there. As of January 2023, speaking of tests concerns, we partnered with Fifth Theory, which is a minority-owned test mindset company. So anyone who doesn't pass the test can have access to a Fifth Theory assessment with feedback to resources. And it's not about the content. It's not about teaching to the test or anything like that. It's about the approach to test taking. We also engaged in a lot of research, including community conversations where we talked to social workers about their journey. This was qualitative research, but we've invested in quantitative research. And certainly working along with other members of the social work community, because we know there is nothing that we can do alone. We have to work on this issue together in terms of the histories that people bring to licensing and their experience through what regulators are going to oversee, which is 20, 30, 40 years in the profession. So we know we have to work together with other aspects of the professional community. And I mentioned the practice analysis, which we're calling the social work census, where people can actually contribute to what the next blueprint looks like. The next slides are this is some of the activities we have slated for 2024. This is the webinar series. One was about some of the things that I covered here, exam development. One was specifically about the psychometrics piece, because we heard questions about that. The third one was about the accommodations, special accommodations that are made under the law, but also social work offers, in addition to special accommodations, certain arrangements. People could make arrangements for special requests for temporary medical conditions like pregnancy. So we also offer things beyond what the law requires, and the qualitative research. And we have a new test vendor. One of the reasons why we're partnering with PSI is the option to look at potentially remote proctoring of exams to help with access to test taking. Could people potentially be taking licensing exams from their home? With the security in place, we believe that they can, and we're looking to implement that with PSI. I mentioned research, the social work census, that includes the practice analysis, but it also includes a huge workforce study to understand who social workers are. So this level of research has never been done before. It's huge. It's going across the US and Canada. And again, we urge social workers, licensed or unlicensed, we urge anyone who is affiliated with the social work profession to respond so that we understand what our workforce looks like and how it's evolving. The compact was mentioned. We are certainly supporters of the social work compact, which, as Matt mentioned, is very new. I believe we have 4 states on board. So let me echo Vicki's support for that for Nevada. Just a little slide on Nevada's numbers versus bordering states. And this is a map that we have available about social workers per 100,000 across the country. And just to wrap things up, I just want to go back to accountability. Regulators are accountable to the public. The process that we go through for the part that we oversee, the examination, is meticulous, but we know that we have to work together with other aspects of the profession, with the public, in order to make sure that every candidate has an opportunity to demonstrate their competence. So with that, I will end. I want to thank you again for inviting us to talk to you about this information directly. I am happy to entertain any questions that you have. And again, if you need for me to come back at some time in the future, I'm certainly willing to do that as well.
Thank you so much for your very thorough presentation. Committee, questions? Okay, Assemblywoman Bacchus.
I just have one simple question. I thought the visual of the number of licensed social workers in the western states was pretty impactful, but just kind of in comparison, I mean, just the number of populations within those states that the social workers serve, because when you look at it, Nevada's very glaring at a very low number, but what does it kind of look like based on population in those western states? Is Nevada still falling short, or are we kind of at par?
So looking at the map, and if you go to, I think it's slide 43, it is kind of low. And that's why I think that the compact is a really good thing to consider, just because of being able to work across boundaries, meaning that if I'm a social worker who left Nevada, but if I still care about a population and I want to practice there, or my circumstances are such that I want to provide services there, I actually could do telehealth in Nevada. I think that one of the things, because it falls on the lower end of social workers, looking at the compact, I think, as Matt mentioned, it's not a panacea, but it's an opportunity for people to still serve Nevada, even if they have left Nevada, or for whatever reason, that's a part of their practice target population. I hope that answered your question.
I appreciate it. It kind of does. I was just kind of looking at the proportion based on population, but you did answer my question. Thank you.
Yeah, it's a little on the low side. Yeah, it's not, yes.
Thank you. Committee members, questions? Anybody up north? Assemblyman O'Neill? No? I just have one. So in 2019, I did a bill with one of my, well, actually, it was my youth legislature, talking about how we needed to make sure that people who were working with students were trained to the degree that a layperson, if you will, could, and it would mean that they would be able to at least identify some of the ideations of depression and suicide. He began his testimony before the committee reading his suicide note that coincidentally was written 1 year ago to the date that he was testifying for that bill. And in it, he said, there are a lot of his friends, they kind of, in school, there are a lot of things that are going on and people, but he said nobody picked up on it. And he was at home, and he said if his mother hadn't gotten curious because she wasn't hearing anything up there, he'd already taken the pills and laid down on his bed, that he would be gone. So here's my question. We know that I'll say here in Clark County, there have been some concerns, not just of teachers and parents, but of the community, about what could be done working with social workers to help in some of these instances. I don't know if you all have thought about that or if it's something that you'd be interested in, but Senate Bill 204 requires every school district in the state of Nevada to develop a training program that's for support staff, administrators, teachers, that's everybody. And I can't tell you how well or not it is being implemented. I know there's some school districts that are doing it and there are some that are not. So given the shifting demographics, not just here, not just in a broad scope with the Western region, but here in Nevada, the demographics are shifting, not only with respect to ethnicity, but also age.
Yes.
Are you all doing anything, or have you thought about doing something that could help us reach the people who need to? Because I just talked about students, young people, but on the other end of the spectrum, I think that Nevada is number 2 in suicide rate for older adults, and some of that can be attributed to the fact that they're basically isolated from their support systems, who live someplace cold like Cleveland or Detroit, but they moved here because it's warm. So Can you speak to that?
So Nevada has done something that I think is incredibly important. I have to renew my license in Nevada, and Nevada requires a suicide course for social workers to renew their license. And that's an important thing because social workers who are not licensed are not connected to regulation and don't have that accountability for their continuous learning. So one of the things that I have to do every time I renew my license is take a suicide course in order to get my license renewed. So that's one step. But I also think what you're talking about is very complex and requires a lot of the pipeline kind of work that we're trying to do, starting with the students, starting with supporting them in their internships, having them. I was the director of field education for UNLV, and I just want to actually take a moment to thank all of the other social workers in Clark County who oversaw students. But I think that starting when they're in school is a wonderful opportunity to plant seeds for what I'll call gero social work, working with older adult populations, and all of the factors that impact our community in Clark County and are, changing with the demographics. There's an opportunity to refine those experiences, not only in the curriculum, but refine those experiences in internships, which you cannot graduate with a social work degree without having an internship, which is important. But I think that's a great place to plant the seed. Now, once people graduate, the school is sort of left behind, and it's the regulators who can support how the the field evolves to meet the local needs. And again, I think a good example of that is every jurisdiction can determine what's needed to renew licenses, and jurisdictions have things like ethics and those kinds of things. Those are standard. But again, Nevada took the step of requiring suicide, which was not the case when I first got my license. So I think things like dealing with aging populations, those kinds of conversations in terms of continuing education and supervisory sorts of experience will be an important start. Certainly not the complete answer, but a great start for the evolving population.
Thank you so much. Thank you so much.
Absolutely. Absolutely.
Okay, committee members, questions? Okay, certainly appreciate the time that you all have taken to speak to us about that. But those two things are near and dear to my heart. You got on one hand, students, K through 12 who need help, and on the other hand, you have geriatric patients who need help as well. So, and for those of you who are here or either listening online, we're going to have a presentation from the Louisville Clinic here shortly. So perhaps there's some information that we can marry between what you've given to us and what they're given to us. Thank you again. Okay.
Thank you, Madam Chair.
Thank you. Okay, we're going to move on to agenda item number 8. Presentation concerning services provided to patients with dementia associated with Alzheimer's or other similar diseases. Does anybody need to take a quick break before we get started? No? Okay. All right. Mr. Schubert, I think you're on deck.
Thank you very much, Chair and members of the committee. I'm Paul Schubert with the Division of Public and Behavioral Health, the Bureau of Healthcare Quality and Compliance. The Bureau of Healthcare Quality and Compliance is a regulatory agency. We license and certify medical facilities and healthcare facilities, and we do inspections and investigations in those facilities to ensure proper care and services are being provided. So that's a little bit about us. Today, the objectives are to discuss licensing requirements for nursing homes and other residential facilities that provide services to patients with dementia. While there are several different types of dementia, this presentation will focus on rules for facilities related to providing services to individuals with Alzheimer's disease and related dementia. There are 3 different types of licensed healthcare facilities: nursing homes, residential facilities for groups or assisted living facilities, and homes for individual residential care that provide services to individuals with Alzheimer's and related dementia. Within these 3 facility types, the individuals live within the facility, and facility staffing is available 24/7 to provide supervision. I'll discuss the major differences in these settings and the relevant regulations specific to dementia. So just some facility characteristics. Nursing homes present or represent the highest level of care and services and have the most robust set of regulatory requirements. There are both federal certification standards for nursing homes as well as state licensure requirements. There are several specific requirements designed to accommodate and protect residents suffering from dementia in nursing homes. Then there's residential facilities for groups, and they're state licensed only. And Nevada recently adopted LCB file number RO43-22, and that expanded the ability of residential facilities to provide care to persons with mild dementia to ensure residents receive services in the least restrictive environment. These new regulations also require resident-centered care and focus on the needs of the individual rather than a one-size-fits-all approach to providing services. And then finally, there's homes for individual residential care. They're also licensed only and can only have 2 licensed beds. These homes may provide services to residents with dementia, but the regulations are minimal and do not speak specifically to dementia. The regulations do assure that residents are assessed to determine each resident's ability to function independently and require the director to possess appropriate knowledge, skills, and abilities to meet the resident needs. So here's our statutes within Chapter 449, which are the healthcare facility statutes. And the first one is that the Board of Health shall adopt separate regulations governing the licensing and adoption of residential facilities for groups which provide care to persons with Alzheimer's disease or other severe dementia, as described in paragraph A of subsection 2 of NRS 449.1845, which is actually the third one on the slide, and I'll go to that one next. If, as a result of an assessment conducted, the provider of health care determines that a resident suffers from dementia to an extent that the resident may be a danger if the resident is not placed in a secure unit or a facility that assigns not less than 1 staff member for every 6 residents, any residential facility for groups in which the resident is placed must meet the requirements prescribed by the board pursuant to subsection 2 of NRS 449.032. So the first one and the third one relate to one another. And then there's the one in the center, which is more general. So the Board of Health shall establish minimum continuing education requirements concerning the care of persons with any form of dementia, including without limitation dementia caused by Alzheimer's disease, for each person who is employed by a facility for skilled nursing, a residential facility for groups, which provides care to persons with any form of dementia. So there's a couple of requirements that relate to one another with regards to residential facilities for groups, and then there's a general requirement that requires nursing homes and residential facilities to provide training on dementia care. So let's talk about the specific requirements for nursing homes. And since all licensed nursing homes in Nevada are also certified to receive reimbursement for providing services through the Centers for Medicare and Medicaid Services, and since the federal regulations account for approximately 85% of all the inspection and investigation activity conducted in nursing homes, it's probably more efficient to discuss the federal requirements that accommodate residents with dementia rather than Nevada's specific regulations. So there's the following language that's found in the Code of Federal Regulations at Section 483. There are numerous resident rights requirements, such as the resident has the right to a dignified existence, self-determination, and communication with and access to persons and services inside and outside the facility. There are also several regulations that specifically mention dementia, such as a resident who displays or is diagnosed with dementia receives the appropriate treatment and services to attain or maintain his or her highest practicable physical, mental, and psychosocial well-being. And then there's a requirement for in-service training that must include dementia management training and resident abuse and prevention training. In all, there are 122 mentions of dementia in the Federal Nursing Home Regulation Interpretive Guidelines. So it's quite a robust set of requirements that we assess facilities for compliance with when we go into them with regards to dementia. Next, the specific requirements for residential facilities. And these are found in Nevada Administrative Code Chapter 449 again, and they contain several specific requirements for facilities licensed to provide services to persons with Alzheimer's disease or other severe dementia. The administrator of such a facility shall prescribe and maintain on the facility premises a written statement which includes evidence that the facility has established interaction groups within the facility which consist of not more than 6 residents for each caregiver during those hours when residents are awake. A description of the manner in which behavior will be managed, manner in which medication is managed, and steps the members of the staff of the facility will take to prevent residents from wandering from the facility. And then the administrator of residential facility, which provides care to persons with Alzheimer's disease who meet the criteria prescribed in paragraph A of subsection 2 of the NRS that I previously spoke about, shall ensure that at least one member of the staff is awake and on duty at the facility at all times. So in other residential facilities for groups, there's not a requirement for awake staff at all times, whereas if a facility has the endorsement for Alzheimer's, then they must have an awake member of the staff 24/7. And this is, these are additional requirements that were added to the administrative code with LCB file RO43-22. The first one is person-centered service plan, means a plan developed for a resident in a residential facility that describes the manner in which the facility will provide for the needs of the resident. And then there's Tier 1 training, which means basic training for employees, training in responding to emergencies, training in working with residents, including without limitation residents with dementia and their families, and an introduction to person-centered care. And then Tier 2 training speaks to the psychosocial aspects of dementia, current science concerning dementia, and signs and symptoms of dementia, and working with persons who have dementia, including without limitation, communication, providing person-centered care, assessment of persons with dementia, and planning the provision of care and assisting with activities of daily living. And then the Tier 2 training must be provided by a nationally recognized organization focused on dementia, which may include the National Alzheimer's and Dementia Resource Center, and the Alzheimer's Association, or their successor organizations, or an accredited college or university or federal or state government. Finally, the homes for individual residential care. Again, these are only 2-bed homes. I really can't expand on requirements with regards to dementia because the regulations for these facilities don't mention dementia. So they really just need to comply with the general statutes and resident rights requirements for provision of care and services. And this has been a really short presentation, but if you have any questions, I'd be happy to answer those. And again, there's my information.
Thank you. Committee, questions? Anyone? No? You have anyone up north? I just have one. So I keep saying this, we're aging, the state is aging, we're graying. Are we on track to have at least the minimum amount of people who are trained or can train here in Nevada as we approach 2042?
You know, Chair, again, for the record, I'm Paul Schubert. That's a difficult question to answer. I really believe that we have reduced some of the regulatory obstacles in ensuring that facilities can become licensed and provide the services, but ensuring that people receive the training. Certainly the staff members that are working in those facilities must receive training and be qualified in order to provide the care and services. But it seems we're always playing catch up, and I think that's perhaps where we'll be in the future unless there's some way of encouraging more providers to become licensed.
Thank you. Thank you so much. As always, a very thorough presentation. Appreciate it. Next, we will have Dr. Went from Cleveland Clinic, the Louisville Center for Brain Health. And welcome, Dr. Went. And I'm so sorry that us changing the meeting around did not allow for you to be here with us in person, but I thank you for going the extra mile. Begin when you're ready, sir.
Thank you very much, Madam Chairman, and thank you, members of the committee. I appreciate the invitation to present on this very important topic today. Senator Spearman has asked me to present about the dementia journey and the needs that arise in a patient and a family's progress through the stages of dementia. I did want to make sure that before we go too far that we're all on the same page in terms of definition of dementia. So dementia officially is an acquired objective decline in cognitive function that is sufficient to impede performance of activities of daily living. So it's important that we recognize that it's acquired. That means a departure from previous levels of function. So this would not include those, for example, who may have a developmental delay. And it's objective. So dementia must be confirmed through standardized testing of cognition that demonstrates that an individual's cognitive performance is below where it should be for their age. And the disability must be related to cognitive performance. So people with acquired objective physical disabilities, for example, we would not consider to have dementia, although some individuals with dementia do, as part of the process that caused dementia, have physical disabilities or dysfunction as well. And when we say that it impedes performance of activities of daily living, essentially we're saying that someone who has dementia would be unable to live independently without assistance. So we put activities of daily living on two basic levels. The basic activities of daily living are the personal care activities, dressing, eating, walking or getting around, managing toileting, communication, and hygiene. And then instrumental activities of daily living, those are higher level activities that are necessary for someone to run a household. So that would include procuring goods for the household through shopping, managing the household with housekeeping and accounting, managing, preparing food and getting one's medications, as well as using the necessary technology and being able to use transportation. That doesn't necessarily mean they have to be able to drive, but they have to be able to get about in some fashion. It's also important to recognize that, as the previous speaker mentioned, that dementia is not a diagnosis. It's a syndrome, meaning it's a clinical state or clinical status where someone's cognition precludes independent living. The most common cause of dementia by far is Alzheimer's disease, but there are many, many others, and they each have their own specific presentations and causes of disability. And then finally, to make sure we're on the same page with talking about dementia, people don't sort of suddenly wake up with dementia one day. Dementia results from an accumulation of negative influences on brain health that outweigh positive influences on brain health. And this starts with genetics, and there's increased risk for dementia if you haven't finished high school, for example. The risk for those who have finished high school but have not finished college is also higher. So there are modifiable risks which have to do with lifestyle, management of medication or medical issues, and then non-modifiable risks, things that we're born with but nevertheless influence our risk for developing dementia. So apropos the last slide, someone's cognitive journey does not begin with dementia. Generally, people will have typical aging, and thankfully, although dementia is incredibly common, typical aging is the more common course for most people. So these are people who don't have symptoms, are functioning normally on a daily basis and able to manage independent life. And if you were to test their cognition, they would test normal. But about 15 to 20% of people as they age enter a status called mild cognitive impairment, where they or someone who knows them well does notice a change in their cognition. However, they're still capable of independent function, perhaps with some backups or devices that they use to support their function, but they can live on their own. But if you were to test their cognition, they would test abnormal compared to other people their age. And then the final stage in the cognitive journey, so to speak, is dementia, where it's pretty clear that the individual does have cognitive dysfunction. It's also clear that the individual is not able to maintain an independent existence, and their testing would be abnormal. And I'm going to focus on dementia specifically. That was the request. Within dementia, we also separate that into phases of mild dementia, meaning that someone is able to manage all of their basic activities of daily living, those personal care activities, dressing, grooming, hygiene, bathing, toileting, communication, and ambulation. And many people with mild dementia don't actually show symptoms very clearly because they are so capable. When someone loses the ability to perform one or more of their basic activities of daily living, and most often this is the ability to dress themselves or to bathe without reminders, then we classify them as having moderate dementia. These folks can still do most of their basic activities, so they may be doing their toileting and hygiene and feeding themselves and able to communicate and get around, but at least one of those personal care activities is now lost. People with moderate dementia typically require constant or near constant supervision. And so you can see how the care needs escalate very quickly when someone moves from the mild to the moderate stage. And usually people spend about 2 years in mild dementia before progressing to moderate dementia. With severe dementia, the individual needs assistance with all of their basic activities of daily living, and they really are not able to function independently. So obviously require constant supervision, but also a fair amount of hands-on assistance throughout the day with all of their activities. And then finally, with end-stage dementia, individuals have stopped communicating. They really not only can't accomplish their basic ADLs independently, they really are minimally able to even assist someone who is supporting them in those activities of daily living. Often these folks are either bedbound, or if they're not quite bedbound, they require a substantial amount of help to transfer and to ambulate. As people transition from mild to moderate to severe to end-stage dementia, the needs also evolve. So this is not a monotonic increase in needs. It depends on the need and the stage of dementia. So one example with medical expertise, there's a high need for medical expertise when people are mildly demented. As I mentioned, sometimes it's hard to tell that something's wrong with them. So it requires a medical expert to detect the abnormal cognitive function, to precisely diagnose what's causing the dysfunction, and to initiate treatment. The medical needs kind of decrease for the most part in terms of expertise in dementia management. There can be spikes in behavioral concerns, or other medical issues might arise where the input from a dementia expert is necessary. But generally, as someone progresses from mild to moderate to severe dementia, their need for dementia expertise decreases. However, once we start to approach end-stage dementia, now we need a different kind of medical intervention where there's a focus on comfort, there's a focus on preventing medical complications like pressure ulcers, dehydration, malnutrition, and in the very end stage, a hospice specialist may be appropriate. The need for education varies quite a bit throughout the dementia course and varies quite a bit with the knowledge of the caregiver and the patient. Again, there's a pretty high need up front when we're talking about the fact that the person has dementia, when we're talking about what specific dementia the person has and why we think that, and when we're laying out a treatment plan and coordinating with the patient and the caregiver to progress with treatment. And depending on what arises during the course of treatment, there may be other educational boosters that are needed. Management of ADLs tends to increase slowly throughout the course of dementia because the ADLs that the patient is able to perform decrease over time. Emotional support varies quite a bit. Cognitive rehabilitation, the need is most intensive early in dementia when a patient is still capable of learning new information. But towards the later moderate, severe, and end stages, cognitive rehabilitation is not of much benefit to the patient or the caregiver. And so again, these needs evolve depending on the specific need, the specific patient, the specific caregiver, and their setting. To break it down a little bit more, in mild dementia, we tend to have a lot of high-cost needs, including specifying the diagnosis and potential disease-modifying treatment, arranging for safety measures, potentially, if someone has to be placed residentially, moving into an assisted living facility. The average, as I understand it, is about $3,500 a month for assisted living in Nevada. Some of these costs vary depending on how the support is provided. For example, disease education could potentially be provided through a web-based platform where people learn at their own pace about the disease that they have. Many of the associations that are associated with these diseases have really excellent websites. That is pretty inexpensive. If you want me or one of my colleagues to sit down with a patient and give them disease education, that's going to be quite a bit more expensive. Another example is with advanced directives. Again, if you want a dementia expert to talk through advanced directives with a patient at the point where they're mildly demented, that's going to be fairly costly. It's an office appointment for a neurologic subspecialist. However, there are technological solutions as well to advanced directives. And there are solutions in between, right? So for example, with advanced directives at our facility, social workers generally discuss these with patients, or our nurses do. Disease education is very heavily dependent at our facility on nurses and social workers as well. As someone progresses to moderate dementia, their needs begin to change. And the caregiver's needs in particular begin to change. Remember, now we're talking about the patient who needs care for their body. And this is a patient who typically is almost certainly not driving anymore. They really can't contribute very much to, say, shopping. They may be losing their ability to do even the most basic household chores. And so you see this transition to a great deal of pressure on the caregiver to perform a lot of tasks that they didn't need to perform before. In addition, there can be increases in behavioral disturbances, which can require a specialist, geriatrician, psychiatrist, or dementia expert. And we also have to think about the fact that someone with moderate dementia they still need the medical care, the dental care that they needed before they had dementia, but now their ability to cooperate with, to participate in that care decreases. And often someone who is specially versed in taking care of individuals with dementia may be necessary. Respite care becomes much more important for the caregiver, where not only the emotional burden, but now the physical burden has dramatically increased. And then training in how to help the patient perform activities of daily living, whether it's training in overcoming what often can be some resistance, to help, or training in just how to manage things. A lot of men, for example, don't know what it takes to clean up a woman who has gone to the toilet. But even basic information like this can be delivered and must be delivered in order to enable caregivers to keep patients at home, which is the overwhelming preference of caregivers and patients pre-dementia. Residential facilities now would need to be dementia facilities, as the previous speaker mentioned, no longer assisted living facility. Some of the household or group homes can also take folks with dementia, but an assisted living facility would be unsuitable because they don't have the support that's necessary. As we progress to severe dementia, the caregiver most of the time will need some kind of help, family or friend, personal care assistant, or placement in a memory care unit. My understanding is that nursing home placement in general in Nevada is somewhere between $7,000 and $9,500 per month. It's a very, very costly option, but inevitable at some point if someone develops dementia. The kind of medical care now really transitions to palliative care, comfort and support for the caregiver. And it's very important, again, that the general medical needs of the patient are attended to, because complications of missed medical illnesses can be very, very expensive at this point. And then finally, in end-stage dementia, we recommend that individuals enter hospice care. There are no treatments specific to end-stage dementia that would not have been employed already. The ADL management, now we're talking about a patient who is in need of assistance with transferring. So just the sheer physical labor that's necessary often requires help. In fact, the Ruvo Center's founder, Larry Ruvo, points out all the time that his mother, Angie Ruvo, had to undergo emergency back and knee surgery about 2 weeks after her husband died, because she had been lifting him up to turn him over, to clean him up, lifting him out of bed, lifting him back into bed, and she never walked again after those surgeries. So these can be devastating complications if caregivers don't have the support and if they can't afford a memory care unit. So I have some numbers from the Alzheimer's Association that talk about where we stand in Nevada. There's going to be a huge strain. There is a huge strain on the system. This map shows that Nevada's expected increase in the Alzheimer's disease population over the 9 years from 2017 to 2025 is going to be over 40%. It's one of the highest in the country, I think third only to Alaska and Arizona. Nevada is already in 2023 seeing 142 million hours given by family and friends who are caregiving for patients. That's the equivalent of 68,000 full-time jobs over the year, and $2.7 billion of unpaid care. There are about 50,000 people estimated to have just Alzheimer's dementia in Nevada, with 84,000 caregivers for those individuals. Nevada's Medicare 30-day readmission rate for individuals with dementia is the highest in the country. So 1 in 4 of dementia patients who are discharged from a hospital in Nevada are back within 30 days. And when Medicare counts readmission, they're talking about for the same problem or complication of the problem. So this is not a new problem. They're coming back for the same problem that they were discharged less than a month before. And then the charges and the amount of money that we spend on hospital readmissions and emergency room charges, we're number 3 in the country, spending $41,608 per year on those readmissions and emergency room visits. And our Medicaid payments have also gone up more than any other state for people who are living with Alzheimer's dementia. It's estimated that we will need more than 3.5 times the number of geriatricians that we currently have by 2050 if we want to serve 10% of the individuals projected to be in the state 65 and older. If we want to serve 30%, we'll need almost 3 times that. And for personal care assistants and similar personnel, we will have to increase by about 51% by 2030 if we want to serve the needs that are projected. This seems almost overwhelming. We will definitely need increased capacity to manage dementia. Managing dementia itself may not be the place where we can get the most yield. By the time someone has dementia, they are on a course that is essentially inevitably leading them towards severe and end-stage dementia with the attendant costs and increase in strain and pressure on the system. And we may be better off looking at preventing dementia, at least at the same time that we try to increase our capacity to manage dementia. We also may be better off not necessarily trying to expand our capacity to be able to handle everyone, but to establish best practices and to improve quality and to use that improved quality as a benchmark or standard for then trying to increase the amount or the quantity of services. All of this requires coordination and navigation, both on the individual patient level, coordinating and navigating the various services that they need, but also at the level of medical care systems. Our own system, although it's built to take care of folks with dementia, runs into coordination and navigation problems all the time. But when we talk about the various organizations at the scale of a state or at a country, the need for coordination and navigation just multiplies exponentially. Well-modeled and meaningful incentives may enable us to build the quality and then the quantity that we do need to take care of folks with dementia. And as those slides showed, these pressures are likely to get worse. In terms of cost, we have disease-modifying treatments that, while they are effective and helpful and hopefully will delay or prevent people from getting to those severe and end stages, they cost a lot. That said, the current disease-modifying medication is about $25,000 per year for the drug, maybe another $10,000 per year for other tests. When you're looking at someone in a skilled nursing facility, we're talking about $80,000 to $100,000 a year to maintain them in a residence. Our population is aging. Nevada's population is particularly aging. And I think people are developing increasing, perhaps inflated expectations for what their state will do for them, what medical providers are able to do for dementia. I mean, people hear all the time about cures coming down the road and the decade of the brain and, a moonshot for dementia. And I have to admit that it sometimes feels as if we haven't achieved very much despite all the effort that's gone in, but people expect results from the effort. And so we have to try and meet those expectations. That's the end of my formal remarks, and I'm happy to take any questions.
Thank you, Dr. Wendt. There is a treasure trove of information in the slides, and if you can send that to us. Several of the members have asked for that.
Certainly.
And I'm one of them. I think that it's given us a real good insight. I've got some questions, but let me ask committee. Do you have questions? Any members? Questions? Anybody up north? Okay. So you said something that was kind of startling. You said one of the things that could lead to dementia would be if you did not finish high school. Can you say more?
Yes, this is Dylan Wint for the record. So, not finishing high school is a risk factor for developing dementia. That does not mean that, if you don't finish high school, you will develop dementia, but you are more likely to develop dementia if you haven't proceeded through high school. And there's a somewhat linear relationship between the degree of educational achievement and engagement and the risk of developing dementia. We think that it represents something called cognitive reserve, that essentially the more that you kind of build up your brain's abilities, do good things for your brain, and the less you expose your brain to negative influences, once a pathology starts, Alzheimer's disease, Lewy body disease, or whatever, that brain is more resilient against that pathology. So this individuals with the same amount of Alzheimer's disease in their brains may differ in the degree to which it manifests because they're more resilient. If Shaquille O'Neal lost 50% of his strength and I lost 50% of my strength, it would have a much bigger impact on my ability to perform basic tasks than it would on Shaquille O'Neal, because he's got so much reserve strength that even at 50%, he's probably still running better than a lot of us. Does that make sense?
It does. And, you didn't really have to throw shade on the running part, but so you said we don't have near the amount of people, and one of the ways we could deal with this is prevention. As a state, what could we do to form some collaborations to build capacity for this in terms of prevention, intervention, and then once the person has entered into the dementia cycle, or the phase, if you will?
Now, I think one of the ways that we could add the most to both prevention and care for folks once they get dementia is mental health. Depression is a very big risk factor. Untreated depression is a very big risk factor for the incidence of depression. And so at the prevention end, detecting and treating depression would reduce the risk of developing dementia. And then once people do develop dementia, in fact, psychiatrists are probably second to neurologists in terms of the amount of training that we receive for diagnosing dementia. And then managing the behavioral complications of dementia. The top 3 reasons that people do end up placed in residences are inability to ambulate, loss of toileting control, so that's bowel or bladder continence, and behavioral symptoms. So that sort of improving our mental health infrastructure, I think, might be a pretty big bang for the buck. So much of the early prevention of Alzheimer's is really about lifestyle. So in addition to education, reductions in heavy drinking, reduction in smoking, encouraging aerobic exercise. Those are some methods by which we could significantly reduce the risk. The quality and quantity of food that we ingest is also quite important in risk reduction. And most of these are in folks middle age and on. The education, of course, is an early life factor. Aerobic exercise is probably an early life factor, or at least it is easier to get a middle-aged person aerobically exercising if they've been doing it before. But middle age is when we start to see these risks. And then general medical treatment. Hypertension, diabetes are also risk factors for developing dementia. Again, the way that we view these is as individual influences, negative or positive, through the life cycle on an individual's brain. And you want to try and reduce the number of negative influences and increase the number of positive influences as much as possible.
Thank you so much. One last question. Vascular dementia.
Yes. Yeah, is that what, are you asking what it is or?
Yeah, yes, sir. What is vascular dementia?
Oh, certainly. Okay, sure. So the brain is very greedy for blood. It requires a lot of blood to keep the brain running. The blood is delivered essentially through an arterial tree. And vascular dementia is when that arterial tree is not delivering sufficient blood to the brain. So that can come in a few forms. One is a stroke, a sudden loss of blood flow to a region of the brain that results in that part of the brain dysfunctioning. If it's a part of the brain that's important for cognition, then you could have dementia from a stroke. Another way is a reduction in blood flow through the small vessels that supply the brain. So they become picked off, but like twigs. Each one of these twigs getting picked off may not have much in the way of symptoms or impact, but as they accumulate, you start to get a pretty sick-looking tree, and therefore a brain that's not getting the nutrients that it needs. And then vascular dementia can also occur if the blood vessels rupture, so hemorrhage. And then there are cases where individuals are continuously getting just a trickle of blood, and it may be that they need to open up an artery. So these carotid arteries, large arteries in the neck, sometimes if people have a severe narrowing, they can actually have symptoms of dementia because they're just simply not getting enough blood in real time. And once that's opened up, they can improve. And it is the second most common reason that people develop dementia, vascular dementia.
Thank you. I'm going to make a statement. If it's true, then yes or no. But it seems to me you mentioned two diseases, high blood pressure and diabetes. And those, I've heard those, present themselves first, if you will, for a lot of the diseases that we have. So the demographic groups that are more likely and increasing in terms of high blood pressure and diabetes are in Black and brown communities, yes?
That is correct.
Thank you, sir. Thank you, Dr. Went, for your presentation. And with that, I think I'll give you a call. I've got some more questions, but I'll give you a call a little bit later. We thank you so much for that.
Thank you, Chair.
All right, thank you. We're going to call now for the Contractors Board. Thank you all for diligently waiting. I saw the look on some of the committee's members' faces, and I think there will probably be at least 3 BDRs coming out of Dr. Went's presentation. At least 3. Okay. Thank you all. Thank you all. Let me say, just before you get started, Margie, I want to say to you that I really appreciate your diligence, you and your staff, in terms of working through a lot of the issues that we've had here. I think the most productive session we had was maybe in 2019, 2017, when we did a whole lot of things, and hopefully the next most productive session will be 2025. So with that, please begin.
Well, thank you. Good afternoon, Chair Spearman, Vice Chair Marzola, and members of the committee. Thank you for the opportunity of letting us provide you with information today on our efforts to combat and address unlicensed and fraudulent contracting activities. As I'm sure all of you know, I'm Margie Green. I'm the Executive Officer of the Nevada State Contractors Board, and I have with me today my Deputy Executive Officer, Dave Bihar, who previously served as our Director of Investigations. So as all of you know, our primary mission is to protect the health, safety, and welfare of the public. We currently serve and address the needs of approximately 18,000 active licensees across the state, while also assisting the public who engages in residential and commercial contracts. While our process for licensed contractor complaints affords many opportunities for consumers to seek financial recovery through the board's Residential Recovery Fund, when eligible, our largest concern resides with the work performed by unlicensed contractors. In these circumstances, the board will still investigate the complaint, but instead of ordering corrective action when issues are validated, cases are referred to the local district attorney's office or the attorney general's office for prosecution. Even with many of these processes and protections in place, fraudulent activity remains a reality in the construction industry. Currently, our most concerning trend is the financial harm resulting from contracts for residential solar. The fraudulent activities are being experienced among licensed and unlicensed contractors who engage in practices that do not align with industry standards or statutory requirements. Although we've made progress in passing legislation recently that heightens the contract requirements for solar projects, it is still not enough to combat the complexity of the issues we're facing. Today's presentation is intended to provide you with the foundation of our investigative process, highlight the types of fraudulent activities we are seeing, and share with you some of our ongoing efforts being implemented to keep the members of our community safe. And with that, I will turn it over to Mr. Bihar.
Good afternoon, Chair Spearman and members of the committee. My name is David Bihar, and I'm the current Deputy Executive Officer for the Nevada State Contractors Board. I'm here today to provide you with an overview of the Nevada State Contractors Board investigative process with an emphasis on unlicensed and fraudulent activity, as well as a brief update on the impact of our 2023 legislative bills. The mission of our board is to promote public confidence and trust in the competence and integrity of our licensees while protecting the health, safety, and welfare of the public. Our focus is centered on consumer protection, licensing and regulation, investigations and complaints, and providing adequate public awareness. Our compliance enforcement and complaint processes, they involve a variety of issues involving workmanship, money owing, industrial regulations, such as out-of-scope or permit issues. As part of our investigative process, we often conduct job site visits and informal citation conferences while administering discipline through administrative citations and also disciplinary hearings. Our criminal enforcement is primarily focused on unlicensed contracting and advertising. We also do proactive enforcement efforts, stings with a number of our law enforcement partners, and we also pursue cases that seek prosecution and restitution for some of our victims that have been taken advantage of. Additionally, our fraud unit conducts additional investigations that deal with more complex matters that might involve things such as the diversion of funds, theft, and even forgery. As part of our consumer awareness efforts, we regularly conduct workshops with members of the public throughout the state, along with additional outreach programs. We offer a variety of resources to individuals and members of the industry. We have brochures, pamphlets. We've also most recently encouraged a widespread media campaign that's included public service announcements with both our governor and attorney general. We conduct social media updates on a regular basis on a number of platforms. And we've also provided consumer alerts to individuals to give them recent updates on new legislative issues and other matters that might be of interest to them. One of the areas of focus for us is that currently the statute of limitations for filing a criminal complaint against a contractor is 2 years after the commission of an offense. Any changes to this would require legislative approval, and that's the current statute that exists. Something we take seriously is abuse that might occur to some of our elders and seniors in our community. As part of our initial investigative process, our board asks complainants to indicate if they're 60 years of age or older on our complaint forms. And during that submittal process, they have an opportunity to mark that form, so we'll indicate that on our behalf. The board utilizes our authority as well, oftentimes, to assess a maximum fine if we determine that a violation identified that an individual was over 60 years of age. We also take that same approach with a number of our prosecutorial partners, and they also have an opportunity, if a criminal case is brought to them, to also bring advanced penalties against somebody. One of the more recent initiatives that we're most proud of and that we've implemented is an increase in public awareness and visibility with respect to unlicensed contractors on our violator website. This program has provided a platform for the public to avoid some of our most egregious unlicensed contractors that have preyed on members of our community in both the northern and southern part of our state. This program has allowed us to post the actual photos and a summary of the illicit activity of these most egregious contractors, so that when a member of the public might be looking to hire somebody, they have an opportunity to view our website and to see if any of the people that they're looking to hire have already been violators with the Contractors Board. This next slide it provides a breakdown for you of our criminal complaint statistics during the 2022-2023 fiscal year. As you can see, the number of total complaints that we received during that time frame was 777. Of those, 524 were for contracting without a license, 237 were for unlawful advertising, and 16 were for fraud. The second column shows the number of total complaints that we closed. Highlighted in there is 11 of them that were closed because they were over the statute of limitations. As Executive Officer Green indicated in her opening remarks, the board has seen a significant increase in the number of total complaints related to residential solar. In an effort to help combat this issue, we're frequently engaged in information sharing sessions and the development of enforcement strategies with the Attorney General's Office and other members to help protect consumers. These ongoing efforts have included enhanced protections under legislation that was put into effect on January 1st of 2024, which mandated new requirements for licensed contractors who perform work on residential solar photovoltaic systems. Another collaborative effort that we're proud of that has been undertaken by the board has been the expansion of our interagency underground economy task force. The purpose of this task force was to combat unlicensed contracting as well as fraud and other illegal construction activities. This coordinated group consists of various agencies and stakeholders across our state, such as business and industry, the Attorney General's Office, OSHA, as well as the Labor Commission. Members of this task force, we meet on a rotating basis in both northern and southern Nevada, and we work collectively to combine our resources to help stop unlicensed contracting across our state, with an emphasis on those that are impacting the economy in illegal ways. Some of the other measures we take in an effort to assure that our licensing requirements are met by those applying for a license. We have specific requirements that must be met by those that are applying. These include the passing of trade and law exams, the ability to demonstrate financial responsibility, and a verifiable proven level of experience in a particular construction field. The misrepresentation of this information or someone's criminal history by applicants can oftentimes be grounds for an actual denial of a license or an administrative citation that's issued by our board. At the committee's request, I'd also like to now briefly provide an update on the impact of our 2023 legislative bills. Starting with Assembly Bill 22, this was implemented in October 1st of 2023, and its purpose was to revise provisions governing the actions that our board is authorized or required to take after the issuance of a cease and desist order for unlicensed activity. To date, this bill has allowed criminal investigators the opportunity to prioritize and address unlicensed contracting on a multitude of levels to protect consumers and licensed members of the industry, and it's also helped to provide us a path for first-time violators. Assembly Bill 23, that was also implemented on October 1st, revised provisions relating to the resolution of certain administrative citations through what's called an informal citation conference. To date, this bill has been extremely effective in helping to timely resolve administrative citations and provide clarification to both licensed and unlicensed contractors regarding best practices and the regulatory requirements under NRS 624. It's improved the efficiency of our disciplinary processes, and it's also helped to minimize unnecessary hearings as well as fees and costs to those that had been issued a citation. The bill has allowed for administrative citations to either be affirmed, amended, or withdrawn following an informal conference. Since its inception, you can quickly see these are just some of the most recent statistics since October. We've held 15 conferences, and as the word is spread that this is an opportunity for somebody to challenge a citation, we expect an increase in this number. And again, it can either be affirmed, withdrawn, or amended. Assembly Bill 27, which was implemented in May of 2023, revised the provisions relating to contractors who provided management and counseling services on construction projects by requiring a general building contractor who provides management and counseling services on a project to have an active license in the same classification or subclassification that they were required to be held by that prime contractor. Assembly Bill 29, which was also implemented in October, revised the grounds for disciplinary action against a licensed contractor who provided a false or misleading statement in connection with the application of another person. To date, this bill has effectively been used by our staff to deter licensed contractors from providing fraudulent or misleading statements to assist others in obtaining licensure without having the proper experience. Contractors who would falsely provide this information could receive an administrative citation or even additional disciplinary action. So it's been a good deterrent to prevent people from doing that. Lastly, Assembly Bill 39, which was implemented also on October 1st of 2023, established mandatory elements to be included in contracts for work concerning certain residential improvements, and also provides for disciplinary action for someone that fails to comply with that. To date, this bill has effectively been introduced as part of an overall strategy to help improve consumer protection for the public with respect to residential construction. Since its implementation, our board has taken an aggressive stance in conducting workshops, webinars, industry bulletins, a number of association meetings, and other measures to help assist consumers and provide them with current knowledge regarding the new requirements that would be required by a contractor regarding residential contracts. This slide is a checklist that our board has put together. We've done a number of things to provide that to the public, and we've also posted that on our website as an additional resource for anybody that had questions regarding that. Thank you again for allowing me the opportunity to present to you today, and I'm happy to answer any questions that anybody might have.
Thank you. Committee members, questions? Yeah, Assemblywoman Kasama.
Thank you, Chair. Is there, in statute, I have to be reminded, for some of these contracts, it still seems, like you mentioned, solar, there's a lot of high-pressure tactics on homeowners when people come in. Is there any right of rescission? You know, they come to the house at 10 o'clock and they're there for I've heard of constituents, you know, they're there for 2 or 3 hours just pressuring them to sign the contract, and then they leave, and then the person is like, oh my goodness, what have I done? Is there any time frame that they can have a rescission of that?
Thank you, Margie Green, for the record. Can I go directly to Assemblywoman Kasama? Yes. Under Chapter 598 for the Attorney General's statute, they put in provisions with the right for rescission. I believe it's up to 3 days to cancel that contract. But we are seeing, I'm sure you have all experienced as well at your own homes, high-pressure sales tactics, especially solar right now. They're at the door. They're bombarding you with phone calls. So we are probably going to be putting forth legislation to address that even further this next session.
So it is a 3-day right of rescission?
Yes, it is.
Okay, wonderful. Thank you.
Assemblywoman Bacchus.
Thank you so much, Madam Chair. Thank you, you both, and welcome Mr. Bihar to our legislative interim committee. I kind of have some couple questions, and I think it goes with what you guys were going with the presentation. One was taking a look at the criminal statute of limitations where there's prosecutions of unlicensed contractors. That basically only allows a 2-year from the date of the offense, and I'm assuming if the date of the offense is when an unlicensed contractor entered a contract with a homeowner, that would be like the date of offense. However, just knowing under 624, you could have up to 4 years to file a complaint with you all. And so it's possible that that time period could miss, and an unlicensed contractor it could be even a person who's like a habitual violator, can kind of like sneak by the system just because of the statute of limitations. Am I kind of understanding that correctly?
David Behar, for the record. Yes, that's the current way that the statute reads.
Thank you, Madam Chair. May I have some follow-up questions? And that's kind of what I was looking at, because I was just like also thinking, and I think people have heard it before. My area of practice is I do some construction law. And so I've also recently seen where maybe an unlicensed contractor could enter a settlement agreement, and that could also delay time. If they enter a settlement agreement and they don't do what they're supposed to do, they could likewise kind of extend beyond that 2-year period and not get prosecuted as well. And there's nothing to kind of capture those people that may be taking advantage of someone, a consumer.
David Behar, for the record. That's correct. One of the things we're trying to do to help raise awareness of that, we've done a lot on the media side to make sure people are encouraged to check somebody's license, to kind of be proactive before they might hire somebody to help avoid those types of situations.
Madam Chair, is it okay if I have some, and you're going right into my next area of questioning, is that consumer awareness. And I know Director Green has been out in the community trying to educate people, but there's just people that still just don't either are on notice of this. And this is kind of personal too, because I have noticed on like house.com, for example, and I don't know if there's any way we could address this, because I know on house.com, some unlicensed contractors will take advantage and advertise blatantly on house.com. Have you guys, I don't know if there's any way, or maybe even looking legislative, if there's anything we can do kind of do that, because I know you all have your rules under 624, but it seems like there's these public outlets that an innocent consumer can go to and kind of being taken advantage of in an environment they feel kind of safe in.
David Behar, for the record. So one of the efforts that we've recently undertaken is a much more robust, aggressive stance toward being proactive in those particular areas. With social media, and everybody does everything on their phone or through a computer nowadays, and everybody's chatting and recommending contractors to each other. Without revealing too much, we take a very aggressive approach to that to try to broaden the message and to bring awareness to that. We're also very much on top of a number of publications that get spread out throughout our state to individuals. They'll come directly to your home, for example. And so we take a broad look at all of those things to try to help prevent that from happening.
I'll make this my last one. I appreciate that, because just kind of seeing it. And one other thing I was thinking of is, because this happened to one of my coworkers, they thought they had a licensed contractor come out, and one of their employees actually was kind of utilizing the licensed contractor's information. And I think that licensed contractor kind of felt obligated. They didn't want to get in trouble with the contractors board. And so I think they're trying to do what's right. Have you guys thought about any legislation, like almost like, I don't know, hold harmless or somewhere where there could be a way to meet? So we're encouraging contractors also to tattle on these unlicensed contractors, like whether it's reporting them. I don't know what it could be, because I'm kind of worried in that situation. The contractor may not sell out its employee because they don't want to get in trouble, but yet that person is getting skills to kind of further like take advantage of homeowners without using their license or trying to use another person's license.
Thank you, Margie Green, for the record. We currently, the proposal I'm submitting to our board for consideration, that is one of the items, so.
Thank you so much, because I see it with these little solar, it was a solar contractor where the employee was out there just kind of going wild. So thank you so much for that.
Yeah, I just want to follow up, and then Assemblyman O'Neill, I'm coming up north. So I think with my layman's mind here, I'm not an attorney and I never played Perry Mason or Perriette Mason. Is there something like, for child abuse and that sort of thing, there's a duty to report? Is there anything like that in statute, or and I don't know, maybe it's a better question for legal, but is that something that we might be able to do to address the concern that Assemblywoman Baucus just went through?
Margie Green, for the record, we'd be certainly interested in looking into that.
Thank you. Assemblyman O'Neill?
Thank you, Chair. Question. You said the statute of limitations is 2 years from the signing of the contract. How about if the work done, is there an extension on that? If the work done, the homeowner would not have seen the substandard work, or work done with not in agreement to the contract, i.e., say flooring or electrical wiring that's behind walls or under flooring that is not up to standard, and it takes several years possibly for it to be discovered. There's no recourse at all that can go through the contractor's board. Did I understand that correctly?
David Behar for the record. Again, people will have up to 4 years to file that complaint if it's with a licensed contractor, and sometimes the issue may not initially be, as you're pointing out, may not initially be noticed.
So how about if it's beyond the 4 years? I mean, child abuse probably isn't a perfect example, but they have years to come forward on that. You may not find out that your plumbing work or electrical work or even the flooring was substandard for when years later, when you go to remodel or there's a fire or some other issue that comes up before that, beyond the 4-year statute. In other words, is there any recourse at all for the homeowner that has paid good money for this work to be done that it was not done?
Margie Green, for the record. I believe that maybe some of those remedies might come under Chapter 40 rather than Chapter 624 after the statute of limitations had run.
Good enough. Thank you very much. Thank you, Chair.
Thank you. Excuse me, Assemblywoman Torres, please.
Thank you, Chair. Thank you for the presentation. It's great to see you both again. My question was specifically going back to the conversation regarding solar in my community, and I think in a lot of vulnerable communities, one of the things that you're seeing with these solar vendors is the door-to-door knocking coming around saying that you have to convert to solar has been some of the messaging. I actually received a paper. They came to my house and said, because of a bill that we passed in 2021, we have to convert to solar by 2030, which is not the bill that we passed, obviously. But then when that information is going around, and there's a lot of misinformation in the community, and I think they're specifically targeting vulnerable communities, the elderly, and maybe, and I think BIPOC communities. So what do we do? Is there a way for those companies then to be reported? What would that look like? And then how do people that, are good citizens that are getting that information, what are they supposed to do with it? I mean, likely these are not licensed contractors.
David Behar for the record. So we work very closely with the Attorney General's Office Consumer Protection Bureau. One of the things I would recommend that if somebody feels they've been taken advantage of is to contact them directly and provide that information to them. We're also working collectively with them to try to combat some of that with these door-to-door sales taxes. A lot of false promises that are made to people with respect to rebates. They're going to lower your energy bill, things of that nature, and then they'll work to try to get somebody quickly into a long-term loan. And that's where we really have seen a significant amount of damage done to consumers, particularly, as you pointed out, to some of the more vulnerable members of our community or seniors that will find themselves in a long-term loan, an 80-year-old individual that's gotten themselves wrapped into a 30-year loan, for example.
Yeah, I think just a couple months ago, they went to my dad's house. My dad's like, "We have to convert to energy," and I'm like, "No, Dad. Like, let me look at this first." So I think that they're being very intentional. But is there anything we can do? Like, I get once you've already done the damage, right? You can report it. But before you've done the damage, like, how do we stop these bad actors before they've even done the damage?
Margie Green for the record. I think it's an ongoing education effort, and that would probably involve PUC and maybe NV Energy, as well as our elected officials. We're trying to get the word out as much as we can. And one thing that's been a little bit effective for us, or we find it's effective, is when we get the media to report on one of these, and then, a lot of people may see that on TV, and we need to, inform the public that I've had those same flyers come to my door. Do you know what the power company is doing to your power bill? And you have to do this. So it's just an ongoing effort, and as many people that we can reach, and we're trying to really extend that effort. I think some of the problem is these salespeople that come to the door, maybe working for multiple companies. They're not. And we changed the law last session so that they're supposed to be W-2 employees instead of going door to door as a 1099 and no loyalty to anyone particular, just trying to get their sales commission. So that just went into effect January 1st as well. Hopefully we'll see the results of that, but we're far from, it's continually getting worse as far as what we're seeing with this particular industry. And we're looking for answers.
Hey, thank you. Additional questions? I just got a couple. So, Margie, Ms. Green, you said that you mentioned something about DA prosecuting. And I think it might go along with what Assemblywoman Bacchus was saying. Someone else asked, once you discover that you've been scammed, the clock starting there or not, because this is what I've heard, that even if they report it sometimes to the DA, there's nothing that happens. And I'm not shading on DAs, okay? I'm not doing that at all. I'm just saying, is there anything that we might be able to do that would make sure there's clarity in terms of that 2-year period? And I, for one, think it needs to be longer because sometimes the way they do these things, you don't even know after they finish, you don't even know that they haven't done something right until a pipe bursts or until, your foot goes through the floor or, the solar thing, burns your house or whatever, so I'm just wondering what can be done if it is discovered 2.5 years, if it's discovered 4 years afterwards, what can be done?
Margie Green for the record. Perhaps it might be best for us to get clarity on that. Maybe I could request an advisory or an AG's opinion to get clarity on that subject because then we would have something in writing that we would know we could continue that effort.
Sam, you want to chime in? Yes.
Thank you, Madam Chair. So specifically, we're talking about unlicensed contracting. And under 624800, the statute of limitations for a variety of different violations of the contractor provisions that is punishable as a misdemeanor. And the first violation of unlicensed contracting is punishable by a misdemeanor. That's 2 years. But in 171095, it provides for an extension of that 2-year period if the offense is committed in a secret manner. And if it is committed in a secret manner, that would extend the period to 2 years after the discovery of the offense. There isn't a lot of case law about what actually constitutes a secret manner when it comes to these contractor provisions. Most of that stuff is sexual assault, sexual abuse, that kind of thing. So saying specifically what constitutes a secret manner in the context of this is a little bit difficult, but it's generally when a crime is committed in a deliberately surreptitious manner that is intended to and does keep all those committing the crime unaware that an offense has been committed. So if it was in those circumstances, it would then extend it out to 2 years after the offense was discovered. But I should say that the legislature can adjust those or clarify them as they wish.
That may go to what Assemblywoman Torres you said about your dad saying, we got to get it done. And so if there was someone else that possibly did it and they're beyond that 3-day right to refuse or whatever, so that could apply to that. Yes, I mean, with clarification, it sounds like it does, but I think what we have to do is tighten it up some.
Thank you, Madam Chair. Sam Quas, Committee Counsel. It could perhaps apply in that situation. Perhaps it would likely depend on the specific facts of the case. And this would be something that the state would have to then prove that it was committed in a secret manner to toll that statute of limitations.
So what if they have something that looks like a license, but it's not a license, and what if they are using someone else's business seal or whatever, and the person thinks that what they're looking at, and I'm trying to remember a conversation that I had. So if they're doing that and they show it to someone and they say, oh, okay, I know that company. Does that make sense to you? They're supposed to, they show you something that looks like a license, looks legal, but it's not.
David Behar for the record. Oftentimes we'll encounter unlicensed contractors that will show somebody a business license, for example, and an average person may think that's actually a contractor's license that allows them to do construction for them. And that perhaps, as was previously discussed, could be considered a secret matter in which somebody tried to conceal something. That's ultimately probably a matter of interpretation based on the individual circumstances of the case.
Thank you. Additional questions? Yes. Mm-hmm.
Thank you, Madam Chair, for the courtesy. I just had a kind of a silly question. I was trying to look it up myself. But on your guys' most wanted list, and I don't know, you kind of showed it in a slide to give people a visual, and it's also displayed in your guys' office so people can see who those, I guess, habitual unlicensed contractors are that are out in the community. With respect to those, how does someone get on that like most wanted list? And are those guys getting criminally prosecuted? Like, do they have warrants? Or I'm kind of wondering what gets you on that most wanted list.
David Behar for the record. So what we have tried to do with that is pick our worst habitual offenders that have had high dollar amounts or have really targeted some of the most vulnerable members of our community, some of our elderly folks and things of that nature. And that's what we've used that for. Yes, and they have been, majority of them have been prosecuted through either the Attorney General's office or the District Attorney's office.
Okay. Thank you. I appreciate it. Anyone up north, questions? Doesn't look like we do. I am pretty sure there's going to be a committee BDR because some of the things that we've been hearing require that. I'm not speaking for anybody but me, but I think there's a special place in hell for people who do that to unassuming seniors. And I saw something on one of the channels. Darcy Spears, I think, was helping a lady who was scammed and didn't know it. And those people that run around talking about solar, we need to make sure that we have in statute that they will be prosecuted to the fullest extent of the law. And unequivocally, very plain, very plain. So that's just my comment. You can respond or not, but that's just my comment.
Thank you. We appreciate your comments and your time today. And thank you so much for allowing us to come in and present. And we're always here if you have any of you have any questions.
Thank you, and thank you all for waiting, okay, so patiently. And with that, I think we're up to public comment. Public comment, anyone here in Las Vegas? I'm looking at Carson City, don't see anyone. BPS, do we have anyone on the phones?
If you'd like to participate in public comment, please press star 9 on your phone to take your place in the queue.
Hello? Hello, am I unmuted?
We can hear you.
Okay, I apologize. For the record, my name is Dr. David White. I'm calling in on behalf of myself as a dentist, as well as a Nevada Dental Association member and chairman of the Council of Government Affairs. Just want to go ahead and lend our support to the compact. We've had a great collaborative effort with the hygienists and also with ADSO and the large group practices. We do have an extreme shortage of hygienists in our region that we are experiencing, and this is really creating a problem because of the collaboration or the syncrasy that we're knowing that's happening between oral health and medical health. In particular, right now it's very difficult for a new patient to be seen by a hygienist. Recently, I had a patient come to my office from Lovelock, and they need to receive chemo, and they're not able to get the cleaning that they need to get done, so there is delayed in their medical treatment. The compact will help. Unfortunately, we need it's one of many solutions that we need to solve this hygiene shortage, and so we just want to go ahead and throw our support behind that, and we look forward to working to correct this shortage. Thank you so much.
Chair, there are no more callers wishing to participate at this time.
Okay, thank you, and committee members, thank you so much for your diligence, for your attention, and everybody who was listening online, thank you for that as well, and look forward to seeing you all here the next bad time, bad place, or something like that. May 23rd. May 23rd. See everybody here May 23rd. Thank you so much, and we are adjourned.